are being held up on the Senate floor. The Senate's duty is to provide advice and consent, not manufacture gridlock. When nominees clear this committee, they deserve a timely vote. Instead, we've seen well-qualified men and women who put their lives on hold and answered the call of public service. They're left twisting in the wind for months. That weakens our justice system at every level. Vacant judgeships mean heavy caseload and long delays. Vacant U.S. attorney offices leave communities without Senate-confirmed law enforcement leadership. That should concern everybody in this country, and particularly in the Senate. There was a time when nominees who cleared this committee were confirmed routinely, often as simply as by voice vote. Now we see a pattern of delay and obstruct. The losers aren't Republicans or Democrats. They're the American people waiting for justice. It's time for the Senate to act. Second, we've heard time and again from my Democratic colleagues that our nominees lack independence from the president. Well, that's a turn of events, because at the Democrats' own partisan spotlight hearing, the Senate Minority Leader bragged that Democrats had stacked the bench with quote unquote progressive judges. He didn't stop there. He celebrated their rulings against President Trump and declared our people are the first line of defense, unquote. Now think about those words, our people. That's not the language of an independent judiciary. It's the language of political ownership. And yet, these are the same Democrats who cry foul and actually accuse Republican nominees of being Trump judges. The double standard is breathtaking. And we're repeatedly hearing from Democrats that nominees must follow all court orders. Let me be clear. Following the rule of law means obeying lawful court orders. But we now have lower court judges who aren't following court orders. As Justice Neil Gorsuch put it just a few days ago, quote, lower court judges may sometimes disagree with this court's decision, but they're never free to defy them, end of quote. He warned that, quote, this is now the third time in a matter of weeks this court has had to intercede in a case squarely controlled by one of our precedents, end of quote. He reminded those on the federal bench that, quote, when this court issues a decision, it constitutes a precedent that commands respect in the lower courts, end of quote. Justice Brett Kavanaugh has made the same point, quote, members of the judiciary have an important responsibility to get it right, to do our hard work, to understand our role in the constitutional democracy. We're not policymakers, end of quote. In March, Justice Alito condemned a federal court for an act, quote, judicial hubris and self-aggrandizement, end of quote. When the highest court in the land uses phrases like defy, hubris, and self-aggrandizement to describe what is happening in our judiciary, it tells you something has gone terribly wrong. All of us should agree. Lawful federal court orders must be respected. That's not a Republican point or a Democrat point. That's the bedrock of the rule of law. It's stunning to hear Democrats accuse Republican nominees of being Trump judges when their own leaders boast that their nominees are his people. Judges aren't supposed to be anybody's people. They belong to a separate branch of government, insulated from partisanship, with only one duty: to follow the law, whether they like the outcome or not. So that brings us to today's nominees: highly qualified men and women who understand the importance of judicial independence in our constitutional design. We'll hear more about Professor Mascott's tremendous resume in just a moment, but let me start by acknowledging that she's well known and well respected by this committee. This committee has called on Professor Mascott repeatedly to testify about some of the toughest constitutional and statutory questions. She also filed amicus briefs on behalf of members of this committee in very important cases. We trusted her judgment then, and we can trust it now. Professor Mascott's qualifications speak for themselves. She clerked for 2 sitting Supreme Court justices. The Supreme Court has cited her scholarship 8 times and even mentioned her by name at oral arguments. At George Washington University Law School, she earned a record 4.22 GPA. Her professors even wrote to this committee to explain that they often thought her exam answers were better than their own answer keys. The kind of intellect that represents, paired with her steady judgment, makes Professor Mascott an outstanding nominee for the Third Circuit. Our district court nominees are also well qualified, and we'll look forward to hearing from each of them today. As a final point, I'll mention that we'll have a long hearing today, 6 nominees, 2 panels, multiple introducers. I'll ask everyone to keep their remarks limited to 5 minutes, allotted to keep the hearing on schedule. Senator Durbin.
Thanks, Chairman Grassley. Welcome back to Washington. Hope the corn crop in Iowa is as good as it is in Illinois.
It's going to be a national record.
National record. I'm not surprised, and I'm sure your farm will lead the way. I want to address the issue which you've raised, and very importantly raised at this hearing, because I think it's time that we discuss it openly and find a solution. I share your interest in ending the impasse we face on the floor of the Senate. For decades, the Senate confirmed U.S. attorneys by voice vote or unanimous consent. All 85 of President Trump's U.S. attorney nominees during his first administration were approved by voice vote, all of them. But early in the Biden administration, things changed. Senate Republicans began a campaign of obstruction. In April 2021, Senator Cotton of Arkansas announced he would block nominees from any state represented by a Democrat on this committee. Senator Cotton finally lifted his hold in December of 2021, but in February 2022, he again blocked U.S. attorney nominees for months. Talk about twisting in the wind. There's another case which I recall of supreme twisting in the wind. Remember when Anton Scalia died on a hunting trip? How long did that vacancy sit there, open, unfilled? At least 10 months. The whole last year of the Obama administration, he was unable to fill the vacancy on the highest court in the land. In June 2023, things changed again. Then Senator J.D. Vance of Ohio announced he would place a blanket hold on, quote, all Department of Justice nominees under Biden, including U.S. attorneys, to quote, and these are his words, and I attributed to him on the floor, grind the Justice Department to a halt. Grind the Justice Department to a halt. On 8 separate occasions, in 2023 and 2024, I went to the Senate floor to request, really to beg for a change from Senator Vance. Give us consent to confirm these nominees according to the Senate tradition. Each time my efforts were blocked by Senator Vance or other Republican senators on his behalf. Due to Republican obstruction, President Biden was only able to fill 68 of the 93 U.S. attorney positions with Senate-confirmed nominees. I appreciate, Mr. Chairman, that you did not agree with Senator Vance's actions back then, and I don't believe you do now. But we can't have one set of rules for Republican presidents and another for Democratic presidents. We also now face a Trump administration making an end run around Senate advice and consent duties. Senator Coons is here from the state of Delaware, and I'm sure he will address that in a minute. In several blue states, the Trump administration has taken an illegal and unprecedented approach to filling U.S. attorney vacancies with extreme candidates while making no attempt to consult with Democratic senators. I learned during the first Trump administration to sit down and work with the Trump White House. We disagreed on almost everything, but when it came to filling judicial vacancies, we filled every single vacancy that I was party to during his administration. We reached an agreement, we both had to compromise, and we did. I think that's the way it still should work. The path forward cannot result in Republican senators having their preferred U.S. attorney nominees confirmed, while Democratic senators have outrageous picks installed in their states in legally dubious ways. I look forward to working with you, Mr. Chairman, and I mean that personally, on a fair and bipartisan solution to this problem. It's been created by both parties. We're facing it now. Let's do something about it in a civil way, in a fair way, and I think we can achieve that. I will tell you, I won't go into detail on the Delaware nominee. I'll leave that to Senator Coons. But I want to thank you for your longstanding bipartisan tradition of requiring blue slips from senators supporting district court nominees from other states. I can give you specific examples where during the first Trump administration, Democratic senators did not approve any blue slips to fill any judicial vacancies in their state. They waited until there was a Democratic president. I can give you another example, a very obvious example, I won't name names, of one state now represented on this Judiciary Committee where the Republican senators filled no judicial vacancies during the Biden administration and waited until they had an opportunity for a Republican president. It's been done by both parties. But we've stood by the blue slip, and I hope we will continue to. I yield.
Thank you. I want to now introduce Senator McConnell. Senator Hyde-Smith, Senator Tuberville, Senator Britt, and remarks from Senator Coons. Senator McConnell, please proceed.
Good morning, Mr. Chairman, members of the committee. It's my honor to be here today to introduce my friend Jennifer Mascott. President Trump made an excellent selection in Jen as his nominee for the Third Circuit Court of Appeals. I've had the pleasure of getting to know Jen over the years through her work as a professor. I can tell you firsthand that Jen has honed a brilliant legal mind, evidenced in both her academic credentials and distinguished public service. This nomination provides the Senate with a prime opportunity to elevate a well-studied constitutional scholar who understands the role of a judge. Before beginning her law career, Jen graduated from the University of Maryland with degrees in math and government. I'm proud to say that early in her career, she worked in the Kentucky congressional delegation as a press assistant. I'm fond of her Kentucky connection and grateful for her service to the Commonwealth. As you may expect, this was just one of many roles where Jen excelled in serving others. After her work in Congress, Jen graduated from the George Washington University Law School with the highest GPA in her class. She even made history by breaking the record for the law school's highest graduating GPA ever. It's no surprise that she's regarded as wicked smart among her peers in the legal community. Jen built her skills during impressive clerkships with the then D.C. Circuit Court of Appeals Judge Brett Kavanaugh, and then Supreme Court Justice Clarence Thomas. Her legal foundation in text and tradition makes Jen exceptionally well suited for a spot on the federal bench. Perhaps the most impactful aspect of Jen's resume is her devotion to teaching the next generation of attorneys. In her tenure at the Scalia Law School at George Mason University and Catholic University's Columbus School of Law, Jen earned a reputation for accessibility to students and robust support for their legal journeys. The faculty at her alma mater, GW, represented a variety of political backgrounds, praised her demeanor, her outlook on jurisprudence, and her stellar qualifications. Jen's fair-mindedness and broad knowledge of the law make her the perfect candidate for federal judge. Needless to say, helping highly qualified legal professionals reach the federal bench has been one of the favorite parts of my job. I've gotten to do it an awful lot. So I can speak with a bit of experience when I say that Jen is exceptionally qualified for the role we're discussing. She will interpret the law as it is written and ensure to the best of her ability that our founder's principle of the rule of law will prevail. Would like to close by recognizing Jen's 4 children, Avery, Everett, Eli, and Augustine, who I'm sure are thrilled that their mom sits before this committee today in consideration to be a federal judge. Jen, you and your family were incredibly strong through the loss of your husband, Jeff, in 2023. Your resilience is an inspiration to all of us. There is no doubt he is looking down today with so much pride in his family. So, Mr. Chairman, thank you for allowing me today to give my insight on this stellar nominee. I'm confident that Jennifer Mascott will serve our country well. Look forward to her consideration and her confirmation.
Thank you, Senator McConnell. Now, Senator Wicker.
Thank you very much, Chairman Grassley and Ranking Member Durbin and my distinguished colleagues on this committee. Senator Hyde-Smith and I have a great honor today of presenting 2 very outstanding members of our state Supreme Court for the position, for the 2 vacancies of district judge in the Northern District of Mississippi. Senator Hyde-Smith has served in the state Senate with both of these distinguished jurists before they went on to the bench. And, well, let me say, she has known both of them as judges, and one of them as a colleague since when she was herself a member of the state Senate. And I will take the lead in introducing Justice Bobby Chamberlain, and Senator Hyde-Smith will take the lead in introducing Justice Jimmy Maxwell, but please know that we support them both. From years of observing the personal character of Justice Bobby Chamberlain, I can assure this committee that he is a rock-solid choice and ready to assume this office. I've known him for many years and had an opportunity to observe him in many capacities. He's a graduate of the University of Mississippi School of Law, and immediately upon graduation, he went back and began work in the private sector. He was actually a partner in one of the outstanding firms in DeSoto County, Mississippi. He has excelled in the practice of private law. He has been a municipal court judge. He's been a city prosecutor for the city of Horn Lake, Mississippi. He's been appointed a special master in Chancery Court. He has worked for years as attorney for the DeSoto County Board of Supervisors, the governing legislative board of county government in our state of Mississippi. And as I said earlier, he served as state senator for DeSoto County for some 5 years, where indeed he did serve with Senator Hyde Smith as a colleague. Then in 2005, Governor Haley Barbour thought enough of Senator Chamberlain to appoint him as a circuit judge in Mississippi's 17th Circuit, a position which he held for over a decade until in 2016, he decided to run for the position of Supreme Court Justice. Now, in some states, that's appointive, but in our state, it is elective, and it is, I think, a testimony to Justice Chamberlain's fairness and even-handedness that in the runoff election for that position of Supreme Court Justice in his home county of DeSoto County, the fastest growing county in the state of Mississippi, he received 93% of the vote. So I think that underscores what I've known for a long time, that the people who know him best have confidence in him, and they've seen him in all of these capacities over the years, and they thought enough of him to give him 93% of the hometown folks. He's a family man. He and his wife, Kim, who is herself a dedicated public servant, they raised their son, William, there in DeSoto County in Hernando and the United Methodist Church of Hernando. Bobby is clearly ready for this role. Again, I endorse both of these candidates, Jimmy and Bobby. I know them by name. I know them personally. They'll both make very fine judges for the Northern District of Mississippi, and I urge my colleagues to approve their nominations. Thank you, and I yield back, sir.
Senator Wicker, thank you. Senator Hyde Smith.
Thank you, Chairman Grassley and Ranking Member Durbin and the members of this committee for the opportunity to be here today to speak on behalf of my two very special friends. I'm especially grateful to President Trump for nominating James Maxwell and Robert Chamberlain to serve as United States District Judges for the Northern District of Mississippi. Both are highly qualified individuals and bring honor, experience, and integrity to the federal bench. I congratulate them on this recognition and offer my full support for their confirmations. As Senator Wicker mentioned, I got to know Bobby Chamberlain as we went into the state Senate together at the same time, and his wonderful wife, Kim, and their son, Will, and I realized how outstanding they all are. Today, it is my privilege to introduce and speak in support of James Maxwell. He has long served the people of Mississippi with a distinction as a man of outstanding character and deep legal experience. Justice Maxwell resides in Oxford, Mississippi, home to the University of Mississippi, where he earned both his undergraduate and law degrees. His legal career reflects a steady rise through increasingly demanding roles, always defined by professionalism and dedication to the rule of law. From 2002 to 2009, Justice Maxwell served as an assistant United States attorney in the criminal division, prosecuting a wide array of serious cases, from public corruption and white-collar crimes to major drug trafficking, gang activity, and violent offenses. His work helped make communities safer and underscored his commitment to justice. In 2009, James was appointed to the Mississippi Court of Appeals, where he served until 2015. There, he worked on a wide variety of civil and criminal appeals and built a strong reputation for being fair, thorough, and a sharp legal mind. Since 2016, Justice Maxwell has served on the Mississippi Supreme Court. In that esteemed role, he has reviewed thousands of cases and authored more than 500 majority opinions. This extraordinary body of work demonstrates both his intellect and his dedication to careful, principled jurisprudence. Altogether, his 16 years on the state's two highest courts, combined with his earlier federal prosecutorial experience, make him exceptionally well prepared to serve on the federal bench. Beyond the courtroom, Justice Maxwell has been an engaged leader in the Mississippi Bar Association and the State Prosecutors Association. And while his professional accomplishments are significant, those who know him best also speak of his humility, integrity, and faithfulness to both law and his community. I'd also like to recognize his wife, Mindy, who is here today in support. Her presence is a reminder of the family and community that stands behind Jimmy and the values that shape his service. In closing, I have full confidence in Justice Maxwell's qualifications, character, and commitment to justice. He will be a tremendous asset to the Northern District of Mississippi and to our federal judiciary more broadly. I look forward to working with this committee and with Leader Thune to ensure a swift and successful confirmation of both James Maxwell and Robert Chamberlain to serve in the Northern District of Mississippi. Thank you so much.
Thank you, Senator Hyde-Smith. Now Senator Tuberville.
Thank you, Chairman Grassley and the committee for holding this hearing. I want to begin by thanking President Trump for selecting these exceptional candidates. I really enjoyed working with Senator Britt on this important task. We need our justice system to focus on upholding the Constitution, not pushing an agenda, and I'm confident that these three gentlemen will respect the rule of law and will be impartial in all their interactions on the bench. It is my honor and privilege to introduce these three individuals who have been nominated to serve as federal district court judges in the great state of Alabama. Number one, Edmund LaCour for the Northern District. Edmund is currently the Solicitor General of the state of Alabama. Before assuming this role, he served as Deputy Solicitor General. Prior to that, he worked in private practice here in Washington, D.C. Edmund was previously nominated to be the U.S. District Judge by President Trump at the end of his first administration, but this nomination was later withdrawn by President Biden. A native of Dothan, Alabama, Edmund attended Birmingham Southern College for an undergraduate degree and Yale Law School for his J.D. Our second nominee, Hal Moody for the Northern District of Alabama. Hal Moody is a partner at Bradley, Arant, Bolt, Cummings, LLP in Huntsville, Alabama, specializing in business and commercial litigation. He has served as the president of the Alabama Defense Lawyers Association's Young Lawyers section and previously served on the Young Lawyers Executive Committee to the Alabama State Bar. Hal is originally from Montgomery, Alabama, and he went to both undergraduate and law school at the University of Alabama. Our third nominee is Mr. Bill Lewis for the Middle District. Bill Lewis is a justice on the Alabama Supreme Court. Prior to being nominated to this role, he served as a judge on the Alabama Court of Appeals, and earlier, he was the presiding circuit judge on the 19th Judicial Circuit. Before his judicial service began, Bill was in private practice in Wetumpka, Alabama. He is a lifelong Alabama resident, having grown up in Wetumpka. Bill attended the University of the South for his undergraduate degree and Cumberland Law School in Birmingham for his J.D. Welcome to all these nominees and their families, which is quite a few, by the way. So thank you to the committee for this opportunity, and I urge swift confirmation of these outstanding nominees. Thank you, Mr. Chairman.
Thank you, Senator Tuberville. Now Senator Brett.
Thank you, Chair Grassley, Ranking Member Durbin, for the opportunity to introduce these outstanding nominees. Today is a great day, not only for the state of Alabama, but for our nation, to get to see these fine men in front of us. I want to thank President Trump for his exceptional leadership in nominating each of these individuals. And I want to thank Senator Tuberville for us being able to work hand in glove to make this happen and move these to in front of this committee. I want to welcome Justice Bill Lewis, Hal Moody, and Edmund LaCour, and their friends and family who are here and with them today. We are so proud to have each and every one of you with us. Before us are 3 nominees for federal judgeships in our state who have superb qualifications and a devotion to the Constitution and the rule of law. I am thrilled that President Trump has nominated them to serve in the judiciary, and am looking forward to their swift confirmation. While each of them will have an opportunity to introduce themselves, I'd like to take a minute to highlight some of their accolades. Justice Bill Lewis has served as a judge in Alabama's judicial system since 2016 and is currently an Associate Justice of the Alabama Supreme Court. Prior to that, he served as a circuit judge for Alabama's 19th Judicial Circuit and a judge on Alabama's Court of Civil Appeals. He has worked as both a prosecutor and a defense attorney and was in private practice for approximately 10 years before becoming a judge. He has also served our state in other ways, including as a member of the University of South Alabama Board of Trustees. As a graduate of the University of South Alabama and Cumberland School, the University of the South and Cumberland School of Law, he has received numerous awards and honors and has served with distinction throughout his career. Born and raised in the River region, this is the place that my children call home, and I have an opportunity to reside. I can say that Justice Lewis has unquestionable character. He is a pillar of our community. His story and his grit inspire all who know him, and I cannot wait for him to be sitting on the bench. Second is Hal Moody. Hal is a partner at one of our state's preeminent law firms, Bradley Arant Bolt Cummings. He has an outstanding record of representing his clients in commercial litigation across our great nation, and he has been named as one of the best lawyers in America for commercial litigation. Hal has been an active member of the Huntsville community, having served as a board member and board president of the Crisis Center of North Alabama, the Development Council of Huntsville Hospital, the Committee for the Future for the Children's Hospital of Alabama, and as part of the Madison County Volunteer Lawyers Program. Every person, every part of our state is seen by Hal, and he has a relentless pursuit to make sure that they're fought for. As a graduate of the University of Alabama for both undergrad and law school, Hal has, throughout his career, consistently demonstrated the qualities that are essential to serving as a member of the federal judiciary. Having known Hal for 22 years myself, I can tell you there is no one else who has the focus. It is unmatched. He has a relentless pursuit of excellence, and he has a deep sense of justice. Finally, Edmund LaCour currently serves as the Solicitor General of the state of Alabama, a position he has held since 2019. A graduate of Birmingham Southern College and Yale Law School, his legal credentials are unquestioned. As Solicitor General of Alabama, he has represented the state in a whole host of litigation in federal court and is admitted to practice before every circuit court of appeals in the United States, as well as the Supreme Court. As a lawyer, he has filed more than 100 briefs before the Supreme Court and has argued 3 cases before the court. Prior to becoming Solicitor General, he was in private practice at firms including Kirkland & Ellis and Baker Botts, and he has also served as a clerk to Judge Brill Pryor on the 11th Circuit. As a fellow native of the Wiregrass, obviously the entire region is proud to see you serve. I believe that all 3 of these nominees will apply our laws fairly, uphold the Constitution, and serve with distinction on the federal courts. I am proud to support their nominations and thank them for their willingness to serve and look forward to their swift confirmations. Thank you, Mr. Chair.
Thank you, Senator. If you folks, we aren't going to ask you any questions, so if you want to go, please leave. Senator Coons, you want 3 minutes for some remarks.
Thank you.
And maybe I'll take a couple minutes after you get done for rebuttal to you.
Well, thank you, Mr. Chairman. Thank you for allowing me to speak to the nomination of Ms. Mascott to serve in the Third Circuit. First, if I might, Professor Mascott, congratulations to you and to your family. I mentioned in our meeting yesterday, I've had several personal friends reach out to me to sing your praises as a wife, a mother, a neighbor, a friend, a colleague. And I, too, want to offer my condolences on the passing of your husband, Jeff, I personally know how devastating pancreatic cancer is. I want to thank you for your service at the Department of Justice and the White House Counsel's Office and your willingness to continue to serve. My question, as I posed yesterday, though, is why that service should be in the Delaware seat on the Third Circuit. You were nominated by President Trump to serve as General Counsel of the Department of Education, a position that fits well with your administrative law and constitutional regulatory background. That nomination was just withdrawn yesterday. Why not serve there? You could serve on the D.C. Circuit, which handles lots of administrative and constitutional cases, many more than the Third Circuit. Why not serve there? You've been nominated instead to sit on the Third Circuit in the Delaware seat, long held by Judge Kent Jordan. You're not a member of the Delaware Bar. You've never appeared or practiced in the Delaware state or federal courts. As best as I could tell, your only connection to Delaware is a vacation home in Bethany Beach. That is in sharp contrast to the jurist you've been nominated to replace. Judge Jordan clerked in Delaware, practiced in Delaware, worked in our U.S. Attorney's Office, served as a district court judge in Delaware. You weren't even admitted to practice in the Third Circuit until May, just 4 days after the White House mentioned you were potentially under consideration. This is not your fault. This is an issue between me and the White House on whether they were ever actually working in good faith with Senator Blunt Rochester and me. We interviewed and recommended several conservative Delawareans, members of our bench and bar. I guess they just were not conservative enough. Apparently, there is not a single member of the Delaware bench or bar the White House thought was good enough, because they have instead nominated a law professor from Washington. Ms. Mascott, I appreciated our conversation yesterday when we met for the first time, but your lack of practical legal experience and your extreme views on presidential power concern me gravely. You're an academic, an advocate, but you have not practiced torts or bankruptcy, criminal law, corporate law, and yet you will grade the work of Delaware's district and bankruptcy judges. Last, in a moment when there is profound tension in our political system and our legal system about the boundaries between Articles 1, 2, and 3 of our Constitution, just a few months ago, you said the Supreme Court's decision in Humphrey's Executor should be struck down. Humphrey's Executor has been settled law for 90 years and is in many ways the foundation of the boundaries between executive power and the work of this body. Now you will testify, I expect, that I can count on you to apply fairly what is left of that landmark precedent. I will close. I hope you come to understand the unique and important, the welcoming and supportive role of the legal community in my state, a place you do not know, but have now raised your hand to serve. I welcome the chance to question you today, but I regret to inform you I will oppose your nomination. Thank you, Mr. Chairman.
I'm going to put most of my statement in the record, but I just want to read some names that are precedent for what you talked about, Professor Mascott. We got Katzman, New York, Second Circuit, Neil Gorsuch, obviously when he was on the 10th Circuit, Judge Beebe, got both of Nevada, got both Senator Reid and Senator Ensign to return the blue slip for them. Allison Reiching is another example. Judge Julie Rickleman, Boston seat on the First Circuit. She never practiced in Massachusetts, but Senator Warren and Markey backed her anyway, and Senate confirmed her. So those are some examples that I'm going to put in the record, but I want to, there's a famous, memorable speech by Senator Tillis begging the committee Democrats to respect his objection to circuit nominee Ryan Park and warned that the shoe would be on the other foot. And this is what Senator Tillis said, quote, "I'm wondering what Tom Tillis needs to show up in the Trump administration, the Tom Tillis that was here the last time, who tried to work with you all on some judges, or the Tom Tillis that reflectively votes no. I will tell you the same thing next year when the roles are reversed. You're either going to make my job harder by doing the right thing, and respecting your colleagues today, or you're going to make my job easier because I'm going to write down, go right down the line with the administration, end of quote. So that's the end of that. Now we're ready for the new nominee. Would you, Professor, would you please come to the table, but don't sit down right away, because I'd like to swear. Do you swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Now you can make your opening statement and introduce anybody that you want to introduce who's here or not here in support of you.
Thank you, Mr. Chairman.
Please push the red button.
Yes, thank you, Mr. Chairman, and thank you to the committee for having me here today. I want to begin by thanking President Trump for the honor of his nomination to a seat on the U.S. Court of Appeals for the Third Circuit, and for the opportunity of a lifetime to serve as a lawyer again, now in the second Trump administration. I also want to thank the many mentors, like the judges for whom I clerked, Justice Thomas and Kavanaugh, from whom I have learned so much. Thank you to Senator McConnell for his warm introduction. I'm very grateful earlier in my career for the chance to serve as a staffer on the Senate and House sides of the Hill, and during part of that time period for a member of the Kentucky delegation, where Terry Carmack of Senator McConnell's office was my chief of staff. Before testifying, I also want to thank members of my family and longtime friends and colleagues who are here and introduce my family. But before that, I want to reflect on several key figures who are not here. My parents, who had children quite a bit later in life. They were wonderful people and made me so much of who I am today. My dad was a minister and helped raise funds for a number of international nonprofit religious organizations, both in Africa and India, and through those efforts introduced us to people from around the world. My mom had been a high school English teacher, and before they had children of their own, they helped raise foster children. They taught the value of hard work, excellence, determination, and a love of learning. And they esteemed public service, helping to develop a deep appreciation and respect for the freedoms we have in this amazing country we're all blessed to call home. And then my husband, Jeff. He passed away from pancreatic cancer about 2 years ago. He was clever, entrepreneurial, and devoted to his family and his God. He became a young leader in our church. He was a great man and father, and his piercing affection taught me and our children a bit of what it means to be adored and deeply known. We were young. After I finished high school at 16, we met in college and were married soon after we finished school. We both at that time worked for this body, Congress, on the House side, and sold one of our cars to pay the security deposit for our first apartment on the Hill. And then with ingenuity and determination, he brought us to where we are today. And here with me are our 4 children, courageous, kind, compassionate, strong, and so much fun. And my parents-in-law, Tom and Jenny, career-long educators in the Montgomery and Howard County public school systems, who essentially have become father and mother to me. My brother-in-law, Brent Mascott, an elementary school principal, plans to be here shortly after he finishes meeting with the school superintendent of the system to start the school year. And my sister-in-law, Amy Mascott, a blue hen, graduate of the University of Delaware, also a public school educator. She generously took the time to attend today, along with a number of other friends and colleagues. It would be an unbelievable honor to enter judicial service, and a gift of the kind of opportunity that in many ways can happen only in the kind of system we have here in America, that provides immense opportunity for education and service, betterment, and selection of one's own profession. Mine was not a family of lawyers. One grandmother, one of 8, was the first daughter in her family to finish high school, as I understand it. One grandfather stayed in school just through the 8th grade. The other was orphaned in his teens, joined the Army soon thereafter, and eventually becoming a short-lived professional boxer and then Baptist minister. A number of cousins have served in local law enforcement. And I would value the opportunity to continue that tradition of public and community service and preservation of the rule of law if this body were to vote to confirm me. Thank you, and I look forward to your questions.
Well, I thought you were going to introduce people that were here, or did you?
Well, my in-laws, Tom and Jenny Mascott, and my children. Thank you, Chairman.
You bet. Thank you. Professor, you've had a rare opportunity to clerk for not 1, but 2 justices on the Supreme Court. Justice Thomas, and then Judge Gorsuch on the 10th Circuit. What did you take away from these clerkships about the proper role of a judge?
Well, Chairman, thank you. I am deeply honored to have been able to serve both alongside and for, and later teach with Justice Thomas and Justice Kavanaugh when he was on the D.C. Circuit. And they both had brought a lot of humility to their service on the federal bench and understanding of the limited role in our system of a federal judge to decide concrete cases and controversies, fairly apply the principles of law, look deeply at the public understanding of text in the Constitution and statutes, and apply the law with justice and fairness and humility without favor to any particular kind of party.
You directed litigation clinics at 2 law schools where students worked on appellate briefs before the Supreme Court and federal courts of appeal. What have you learned from mentoring students in these real-world cases, and how will that experience shape your approach to complex appellate cases when you're on the bench?
Well, thank you, Senator. It was an immense honor to be able to teach students, first as an adjunct at my alma mater, GW, and later at Scalia Law School and Catholic. And I was so happy to come in this morning and see actually several former students working here as staffers present right now at the hearing, working for you all, and continuing just a great tradition of service. With the work, particularly in founding the student litigation clinics, focused on issues of separation of powers, those were great opportunities to help students get practical experience writing briefs, looking at important constitutional issues. The clinics had the honor, as I believe you mentioned earlier in your opening remarks, at times of even filing amicus briefs in the Supreme Court on behalf of members of this committee, sometimes even for as many as 100 members of Congress in important cases dealing with student loan payments, the meaning and significance of the now reverse Chevron doctrine, and other important issues cutting across all 3 branches of government, the important role of freedom and limited government in this country. That's a tradition I know this committee is working every day to try to uphold as well.
You've been before Congress many times on topics ranging from executive privilege to the role of federal courts and the administrative law. How has that experience shaped your perspective on the judiciary's role in our system of separated powers?
Well, Senator, I was really grateful for the opportunity here in this committee and also on the House Judiciary Committee, as you mentioned, to be able to testify a number of times courts in the confirmation hearings for 2 Supreme Court justices on issues of regulatory law and executive privilege. And with the committee's often exacting questions, it was really an opportunity to see how this body unpacks legal questions and is dedicated to its role in our system, which, of course, in Article 1 is really preeminent with policymaking and establishing rule of law, preserving freedom. And I was really grateful the committee brought me in to unpack issues, not only how the 3 branches at the federal level interact, but also the way in which the federal government's designedly limited role preserves freedom of the states to be able to govern people and preserves freedom of families and religious institutions and folks in local communities.
I referred in my opening statement about how your scholarship has been cited by the Supreme Court in more than one opinion, and you've even been referenced by name during oral arguments. How has your experience as a professor and scholar influenced the way you would approach precedent as a judge?
Well, the opportunity as a professor to study and teach and write on the Constitution would be foundational, because it has really increased even more my love and respect for the document for our freedoms, and provided a lot of opportunity to dig deep in the history of understanding the meaning of the texts and phrases in the Constitution, and how the founders in drafting and then ratifying among the state ratification conventions that text were focused on preserving liberty and freedom and wrestling with accountability for governmental actors and focusing on the preeminence of elections in selecting policymakers.
Senator Durbin.
Thanks, Mr. Chairman. Professor, welcome back.
Thank you.
I'm glad you're here today, and congratulations on your nomination.
Thank you.
You clerked for Justice Thomas on the Supreme Court. You also testified before this committee against the Supreme Court ethics reform legislation at a hearing in June of 2023. That hearing followed investigative reporting that revealed Justice Clarence Thomas received and failed to disclose gifts worth millions of dollars, with some estimates placing the total value at over $4 million. This was confirmed by exhaustive committee investigation and subpoenas that my staff and I conducted when I was chairman of the committee. So I have several questions I'd like to ask you first. If you are confirmed to serve on the Third Circuit, will you commit to abiding by all the rules and regulations governing judicial ethics, including federal statutes and the Code of Conduct for U.S. judges?
Oh, Senator, absolutely. I would be committed to all ethics requirements. Yes, Senator.
I'm going to assume, unless you say otherwise, that you had no personal knowledge of Clarence Thomas's receiving any gifts.
Senator, of course, that is correct. I was his law clerk. Yes.
All right. You came before this committee to testify on an effort we're making to try to establish a code of ethics for the highest court in the land. We know that there is a code of ethics that applies to federal judges other than the Supreme Court and how it is enforced. And we're trying to write something that would apply to Supreme Court Justice Thomas or any others who have millions of dollars worth of undisclosed gifts. Since you came and testified against our legislation, I'll ask you a very general question. How do you believe the Supreme Court should be governed when it comes to ethics?
Well, so Senator, I was grateful to have the opportunity to come here back at that time during a challenging time. Just on your earlier questions, I just need to say again how honored I was to serve as a law clerk for Justice Thomas and have the deepest respect for him and his character and his integrity. I appreciate your question about Senator Whitehouse's proposed legislation at that time. In my recollection of my testimony on that act, and I think I may have been the only Republican witness in the committee testifying that day. I could be wrong about that, but that we were talking about the various constitutional or not aspects of the bill, and that my testimony focused not really on policy questions of ethics, but some of the particulars in the act, like the lower court panels sitting to evaluate recusal decisions of Supreme Court justices, and that I was pointing out that in our system that has the Supreme Court vested with judicial authority at the top of Article 3, that there were real constitutional questions about allowing inferior judges, is referred to in the Constitution, inferior courts, to sit in judgment really of any decisions of the Supreme Court, and that there were also a lot of open questions in our system about the way that ethics decisions should be adjudicated. But I do not recall commenting on the policy of the justice's decision to file recusals. And again, my understanding is that even though it's not covered statutorily in quite the same way as lower courts, that the Supreme Court, by its own statements and commitments, upholds the statutory recusal requirements in exactly the same way and with the same rigor that lower courts do.
So when it comes to the constitutional compliance, do you believe that receiving millions of dollars in gifts and not disclosing them is in the best interests of our Constitution?
Well, Senator, again, and I don't mean to comment first on the premise of the question. My recollection is that all reporting requirements there were dealt with and addressed. And the constitutional question, again, I think the provisions in the bill, as I recall, that were the focus of my testimony, are about how these types of requirements are to be enforced. And the Supreme Court, as I recall, I think a statement by Chief Justice Roberts at the time, again, emphasized how devoted the Supreme Court and every justice is to complying with ethics requirements. The main constitutional and legal questions before the committee that day were which actors in our system are responsible for making sure those agreements are followed, and questions about how two co-equal branches are to interact and how lower court judges interact with superior court judges.
I think the reputation of the Supreme Court is important enough for us to be willing to consider new ideas on enforcement. Current rules do not work. There are too many gifts that go undisclosed to the justices serving on the highest court of the land. the Supreme Court of the United States, the highest court in the land, should not have the lowest standard of ethics. And when you testified, and as you mentioned, the only one who testified against this bill for reform, it left a lasting impression with me. I respect very much your education and what you've achieved in your life. It's remarkable. But this is one question that still remains unanswered as far as I'm concerned. Thank you very much.
Thank you, Senator.
Mr. Chairman, point of order, could you ask your team to either turn up the air conditioning or build a fire, one or the other?
Sure, somebody heard the request. Senator Lee.
Thank you very much. Ms. Mascott, it's a pleasure to have you here. We're grateful to have you here. On this last point, I do think it's important to remember the separation of powers matters. We're talking here about a coordinate branch of government, the highest court in the land, the Supreme Court of the United States. Unlike the lower courts, is not a creation of the Congress. Now, we determine its size, but we can't relegate that into non-existence as we theoretically could do with any of the inferior courts. And so when we're talking about the apex of a coordinate branch of government, the question is not whether to have those standards in place. The question is who sets them and who does not. And that is not a question of whether you want rules to apply. They do have rules, but they are rules that they themselves have adopted consistent with existing federal law. Ms. Mascott, you've been nominated to the U.S. Court of Appeals for the Third Circuit, a court that's near and dear to my heart, as I served as a law clerk back during the William Howard Taft administration in that, and enjoyed that immensely. So you approached this role. Tell me how you would go about interpreting text, statutory or constitutional, as that's arguably the single most distinguishing feature of the judicial role, particularly the judicial appellate role.
Yes, Senator. So in looking at statutory and constitutional text, I would be looking for the plain meaning or the public understanding of the text that is before the court in that particular case. And as this body knows, that often it always includes starting with the text itself. Not just the text of the word in isolation, but understanding whether the phrase is a legal term of art, looking to the surrounding provisions, looking to how the word is used in other legislation enacted at the same time. Oh, but another important point is the timing of the meaning of the phrase would, of course, be relevant based on the time the document became law. So for a statute at the time it was enacted, and for the Constitution at the time it was ratified by state conventions. And if there's still, question to get background, other times people will use the evidence of outside sources to understand what the common understanding or plain understanding of a text would have been. So in my work, the Stanford Law Review article is probably the most emblematic of my deep look at a constitutional phrase. I also looked at dictionaries at the time of ratification and used actually a technique that was coming into use at the time called corpus linguistics, put forward by Brigham Young University with its databases to look at thousands of uses in ordinary or legal language about how a word is used to further understand its meaning. And the importance is to know exactly what definition of meaning was given legal impact by the folks voting on the text at the time, which is why one wants to understand not only how the decision makers themselves, but the public more broadly understood it, because it's not about the individual mind of the legislature, but the objective meaning of the text in the document.
Fantastic. I can't wait to tell my brother about your plug for corpus linguistics, especially out of BYU. And I think that's important when we talk about that approach, looking at the original public meaning at the time of passage, if a statute, or at the time of ratification, if it's the Constitution or a subsequent amendment thereto, is important, and that does matter. In fact, it's exactly what matters. Now, insofar as the meaning of the text is plain and clear on its face, it's going to be an easier task. Where there are ambiguities, that's where lawyers earn their fee, and that's where judges do their best and hardest work. Of those things where it's not plain, what are some of the things that you would look to resolve ambiguities, and in particular, to what extent is it helpful to gain insight into statements perhaps reflecting a particular subjective viewpoint of a particular lawmaker on something. And by that, I mean floor statements, statements made in debate and so forth.
So Senator, if there was a text where the meaning wasn't originally clear, and as an attorney in the Office of Legal Counsel at the Department of Justice, this was the kind of question we often received. So in my experience, it should take a lot to reach the conclusion that text is truly ambiguous, that a lot of hard work should be done looking at that phrase and surrounding phrases in advance, and as I mentioned before, dictionaries and other sources. You mentioned the particular statements of lawmakers, so what we sometimes call legislative history. So if it is a collection of statements looked at as one piece of evidence, perhaps okay, but there would never be an instance where the intent of one individual person would have legal impact on the meaning of a text, because the Constitution in Article 1, Section 7 made this whole body, through bicameralism and presentment, and the president responsible for enacting text institutionally and not just one by one.
So in other words, even if you could take one of those statements, and even insofar as one of those statements evidenced a subjective intent on the part of that lawmaker, that isn't relevant, regardless of whether they subjectively believe that, unless that was somehow consistent with the original public understanding of it. That really has no bearing.
Correct, Senator, yes.
Okay. Thank you. I see my time's expired. Thanks, Mr. Chairman.
Thank you. Professor, are you a member of the Delaware Bar?
Senator, I am a member of the Virginia and Maryland bars as a longtime public servant here in this
Have you
area.
ever practiced law in Delaware?
Senator, I am admitted to the Third Circuit. I've practiced law, as I mentioned, as a public servant, mostly
Have
here
you
in
ever
government.
practiced law in Delaware?
Senator, I have not. I've practiced law in this area.
Have you made any argument in the federal or state courts of Delaware?
Senator, again, as a public servant.
You can treat these as yes and no questions, please, Professor. Have you ever filed a brief in a Delaware court?
Senator, I filed a brief in the Third Circuit. As your questions point out, as the president's nominee to the Third Circuit, I've been nominated to a seat that by custom now is within Delaware, and would look forward, if this body were to confirm me, in joining the legal community specifically in Delaware. I would plan to have chambers in Wilmington, but right now my practice has been as an academic and here in Washington, D.C. as a public servant.
So your record of scholarship and public commentary, advocacy, is quite lengthy, but I'm concerned that your actual practice is quite short. How many depositions have you taken or defended?
So, Senator, as principally an appellate lawyer and
I think the answer is none. How many motions in limine have you argued?
Senator, my practice has been mostly at the appellate level. So I've filed dozens of appellate briefs. I have not argued motions in limine. I did argue to verdict, however, as the record shows, a district court case defending the Title IX for the Department of Education, and so have argued in both district and appellate courts on behalf of the federal government.
My point is simply that the Third Circuit's docket is substantially made up of criminal cases, bankruptcy cases, patent cases, very little in terms of constitutional administrative law, which is your specialty. And you've been nominated to essentially rule on appeals from the district courts, in particular the district courts of Delaware, and this long, long tradition of states getting to choose a member of their bench and their bar to go to a circuit is so that the values and the tradition, the legal concerns of that state are most respected. Let me move to your substantive work, because my core concern is that our framers drafted a constitution in order to constrain powers, the separation of powers, which you've taught. They put Congress as the Article I branch, not the president, because they were principally concerned about constraining an overreaching executive. In a brief that you filed challenging President Biden's effort to cancel student debt, you wrote, "The power of the purse is one of Congress's most potent checks on the executive branch." I asked you yesterday if you'd ever advised the White House on impoundment issues, whether President Trump could refuse to spend money Congress has appropriated. And you said that you had. Did you advise the White House President Trump can refuse to spend money legally appropriated by this body?
So Senator, I appreciate your question reference to Article 1 and appropriation. I know we talked about that a bit yesterday. And also, having clerked for Judge Kavanaugh, he, as a former executive branch lawyer, also pointed out the president's role in having to sign off or veto legislation. The particular question you talked about, I believe, I recall in our discussion that I had mentioned that I had not been working on that issue recently, that I was asked a discrete question actually prior to the start of the administration on the constitutional question that or related to that topic. But beyond that, really sitting here today as a judicial nominee with some of these issues playing out in the courts as we speak, I cannot further comment on the question.
You publicly stated in March of this year that the Supreme Court's 90-year-old Humphreys executor case was wrongly decided. Do you stand by that statement?
So, Senator, as an academic, and I've taught in other forums, I strongly stand by my past work. Sitting here as a judicial nominee, what I also mentioned yesterday a number of times was my commitment as a lower court judge to a fully and completely applying Supreme Court precedent, and also the case that you mentioned, Humphrey's executor, in the Supreme Court's own writings that has referred to it in the past decade, 10 or 15 years, as a narrow exception to the broader principle that the president, vested with the executive power, needs to supervise the executive branch, and I would apply all those principles fully.
You were just in an exchange with Senator Lee where you talked about the importance of hewing towards the text. I think the Federal Trade Commission Act of 1914 could not have been clearer. In fact, the Humphreys executor decision was a unanimous decision by the Supreme Court, and it has been respected not as a narrow exception, but as frankly the foundation of the boundary between the president and dozens of critical regulatory agencies. It prevents a president from whimsically removing based on partisan, political, or policy differences, something FDR was trying to do to a member of the FTC. Yesterday, the D.C. Circuit reaffirmed the holding of Humphrey's executor. Why should we have confidence that we can count on you to uphold this 90-year precedent that just months ago you have argued was wrongly decided? Will you recuse yourself from cases applying that precedent, given your advocacy for its reversal?
So, Senator, if I were to have the honor of this body to confirm me, I would follow all statutory recusal requirements, and I understand one of those requirements to be to recuse from particular matters on which I would have worked, and also cases where I might have a financial interest at stake, and of course I would fully comply with all statutory recusal requirements.
Last question. Do you think Congress can constitutionally restrict the removal of any official in the executive branch on any basis, whether it's for inefficiency or neglect of duty or malfeasance? Because as is currently being hotly contested, there are critical boundaries between Article 1 and Article 2 powers, and you have been a relentless activist on behalf of expanding the scope of executive power. Is there any way Congress can restrict the removal of any executive branch official?
Senator, as you point out with it being contested, the contours of the constitutional power of Congress to constrain the president's supervisory power or to fashion characteristics on the contours of the institution of offices is currently being contested in courts, and so I'm not going to be able to speak to the absolute merits on that question. We did discuss Congress's role in fashioning and creating offices. We discussed the president's power to supervise the executive branch, and as I mentioned, if I were to have the honor to be confirmed, I would fully and faithfully apply the text and structure of the Constitution and decisions by the Supreme Court, of which I would be fully bound. Thank you.
Ms. Mascott, you come from a great family. You've been a fierce, determined, and capable professor. I appreciate our conversation yesterday and your answers to my questions today. Thank you.
Senator.
Senator Kennedy.
Professor, congratulations. I believe you testified that you think the Constitution should be interpreted according to its original public meaning. Is that right?
Yes, Senator.
What does original public meaning mean?
Yes, Senator. So the original part of that phrase refers to the fact that when we look at interpreting a text, we want to interpret it. At the time it was
Professor, look me in the eye and just answer my question. What does original public meaning mean?
It means the meaning that the text as it was understood by the public at the time it became law.
Okay. So you think Brown v. Board of Education was incorrectly decided?
Well, Senator, I think Brown versus Board of Education was correctly decided. Scholars who have looked at the original meaning of phrases at that time and the reasoning in that case sometimes question the reasoning of the case.
How many people in the United States of America at the time the Constitution was drafted do you think supported racial integration of schools? You think that was a majority view, do you?
Well, Senator,
At the time, but first, Professor, do you think that was a majority view? Do you think most Americans at the time the Constitution was drafted supported integration of public schools, racial integration?
well, Senator, I don't know as a sociological matter what percentage of people thought what at that time. I should point out that when we got to Brown versus Board of Education, of course, there had been several
But
fundamental
isn't that
amendments to the.
inconsistent with your statement that you have to interpret it according to original public meaning?
Well, what about the 14th Amendment and the 13th Amendment and the 15th Amendment? So original public meaning would mean
what
with
about?
those. Well, that would mean we would interpret those amendments and those protections with the understanding of the text and structure at the time those amendments were ratified, which is different, of course, in the 19th century.
Let's go back to Brown v. Board. Look, I think Brown v. Board was correctly decided, and I suspect you do too. But if you say we interpret the Constitution according to the way that people at that time understood it, do you really think that people at that time in America supported racially integrated schools? Do you really believe that?
Well, Senator, I think at the time of the ratification of the 13th, 14th Amendment, and 15th, all which
But
have.
do you think people at that time supported integrated schools?
Well, Senator, on that particular question, I don't know it as a policy matter whether they were thinking about that particular issue. I think they certainly understood that the 14th Amendment, for which a massive part of this country essentially lost lives fighting the Civil War, certainly understood it to require racial
Professor,
equality.
You're not answering my question. I'm just trying to understand how you think. It's very easy to say, we interpret the Constitution according to its original public meaning, which as I appreciate your testimony, means the way people who read the Constitution at that time interpreted it. Is that right?
Yes, Senator.
Okay. Do you think that most people at that time looked at the United States Constitution and said, well, here it is, big as Dallas, racially integrated schools are required? Do you really believe that?
Senator, I don't know, but
And if you don't, I don't think you do, because I think historically that wasn't the case. So how do you square that with the holding of Brown v. Board?
Well, I guess what I'm trying to say is I think there are several steps in between that have not come up yet in our conversation, which is that you look at the text and structure, which of the 13th, 14th, and 15th Amendments clearly is requiring racial equality. And then over time, that has to be applied to different questions as they arise in context. So if the requirement is that all races be treated equally under the law, and the evidence shows that segregated schools is not doing that, then the requirement could be applied to integrate schools.
When you interpret a statute, you talked about interpreting it according to its plain meaning. What if the statute is ambiguous?
Well, Senator, if the statute
What do you do if it's ambiguous?
If it's ambiguous on the particular question coming before the court, I start with that phrase, but I also look at the context of surrounding provisions.
No. I understand you define ambiguity as the language plus the surrounding language.
Yes.
I get that part. How ambiguous does it have to be? 51% ambiguous or just a little bit ambiguous?
So I have to say I would use the same approach essentially in all cases regardless of the ambiguity, because I would always start with the text, move to the surrounding provisions with the aim of fully understanding what Congress and the President had enacted. And only at that
Professor,
point...
I'm going to run out of time. with respect, answer my question.
Well,
Okay, you're giving me professor talk. How ambiguous does it have to be?
I mean, I think under the Supreme Court's recent precedent in Chevron, it underscored that the court can never just rest and say it's ambiguous. The court has to come up with an answer.
Yeah.
So
So
I
why
would,
don't you just look at legislative history?
well, well, you can't look at legislative history of statements one by one because
Why
the
not?
individual
Why not?
intent. Well, Senator, with respect, because this body has its role in our system as an institution, not one by one. So your personal understanding of the
You don't-
law doesn't
This will
matter.
be my last question, I'm sorry. Well, Coons went way over. So you're telling me that it doesn't help you at all to go through and look at the congressional record or read the committee reports or any of that? You don't think that's helpful in interpreting what a statute means?
It depends on the way in which it's being read. If it gives helpful statutory history, if it helps to refer to other portions of context, sure, but not to give it legally binding impact in and of itself. I would always be looking at a broad range of sources and use each of these statements as just one piece of evidence about what people understood the statute to mean at the time. So no, I would never take a piece of legislative history in isolation and give it legal impact.
Thank you, Madam Chair.
Thank you.
Senator Blumenthal.
Thanks, Madam Chair. Thank you for being here, and congratulations on your nomination. I would say that prior to the Dobbs decision, you were a pretty zealous advocate of overruling Roe. Is that correct?
Senator, I do not recall ever advocating for the overruling of Roe.
Well, I think in December of 2021, you said, quote, most constitutionally correct decision, the most constitutionally correct outcome in Dobbs would be for the court to conclude that the 14th Amendment due process clause, a guarantee of process protections, contains no substantive right. Is that your position?
Senator, yes, my scholarly and academic work would have been consistent with the outcome of the Dobbs decision and understanding there not to be a substantive due process clause in the 14th Amendment.
You called the draft of Dobbs when it was leaked in May of 2022, quote, a marvel of a draft, end quote. You think it's a marvel of a draft? It became this court's decision and its opinion in the case, correct?
Senator, it did. And so, yes, I mean, I have spoken highly of the Dobbs decision. As I mentioned previously to the senators on the committee, would fully and faithfully apply the Supreme Court precedent and was happy to, when asked, provide extensive commentary about the constitutional methodology in the Dobbs opinion. I think actually some of those statements might have first happened again in a hearing by this committee, because as I recall, there was a subcommittee hearing on Senator Whitehouse's ethics reform bill the morning after the opinion was leaked, and this committee was asking for feedback
you
about
called it a marvel of a draft.
Yes, and I wrote also in the Wall Street Journal about the opinion as well, Senator, yes.
And you said about Roe that it was, quote, not workable and, quote, really sat far out of the mainstream of constitutional reasoning of the court over the past few decades. You said Roe was out of the mainstream after it was well-established and well-accepted law for decades?
Well, Senator, yes, consistent with the Supreme Court's own majority holding in Dobbs, which pointed out that even using traditional stare decisis factors, the Roe versus Wade decision was not one that merited the court's stare decisis effect because of the development in the law over time, the fact that the Supreme Court itself had distanced itself even in follow-on decisions about abortion from the Roe reasoning, and pointed out that the court's text and tradition approach led to a different outcome in Dobbs, leaving the policy decision to the states and the people.
With apologies, interrupt because I have limited amounts of time. You were asked also about the ramifications of Dobbs, and you, in effect, dismissed concerns that Dobbs would affect other substantive due process cases and you said, quote, Loving versus Virginia, contraception, those are so far away from the court's decision in Dobbs that they almost should not even be, I think, discussed in a realistic sense at this point in time based on this particular decision. So you do not view Dobbs as impacting in any way Loving versus Virginia or contraception cases, is that correct?
No, I read the court in Dobbs to be very specifically grappling with the issues before it and looking case by case at the relevant history of its own reasoning in that line of cases. And I think the court in the majority opinion made that very clear, and then there were also some concurring opinions that underscored it, Senator.
So you see Dobbs not requiring or implicating the potential reversal of those other decisions?
That's correct. Not at this time. And of course, as you know, the only reason a case even gets to the Supreme Court is if the people have litigated it. And I think the point I was making, those comments you referenced, is that Dobbs was very specifically oriented towards one line of cases being litigated at that time. Thank you, Senator.
And let me ask you about one other area. You've been an active member of the Federalist Society, haven't you?
Yes, Senator.
And in fact, you received the Federalist Society Joseph Story Award, which goes to lawyers who have demonstrated excellence in legal scholarship and who have made significant public impact in a manner that advances the rule of law and free society, correct?
I was very honored to get that. Yes, Senator.
But I'm sure you're also aware that President Trump has attacked the Federalist Society, claiming that it gave him bad advice on his judicial nominees, and he's called its founder, Leonard Leo, a sleazebag. Do you agree with President Trump's criticisms of the Federalist Society?
Senator, I believe your statement is touching on judicial nominations, and President Trump, alone, of course, is responsible for nominations. And other than that, I think I'm happy to answer questions about my nomination, but I have, as you point out, a significant background with the Federalist Society and was honored to receive the award.
Senator Blackburn.
Thank you.
Thank you, Madam Chairman. Before I ask my questions, I do want to make a comment. And Chairman Grassley touched on this at the beginning of the hearing. It is so disheartening, and actually it's almost laughable, to hear our colleagues on the other side of the dais complain about lack of consultation with the White House. Now, under President Biden, there were numerous members, and Senator Grassley mentioned Senator Tillis also this morning, and me, and Senator Hagerty, that were not consulted at all. And there were not one, not two, but 3 judicial nominees that the Biden White House moved forward on without working with Senator Hagerty and me. So my colleagues across the dais had the opportunity to say something about those actions at that time, and they chose not to. They all went along with what they felt like was the position of the White House. So I find it, as I said, concerning, disheartening, and really curious as to why they would take the position they have. Professor Mascott, I want to give you a chance to respond to some of the claims that I've heard from my colleagues across the dais that you're not qualified for the role. And I found it very interesting to hear them talk about this because they rubber-stamped people that were brought forward by the Biden administration who were blatantly unqualified, and they were inexperienced judicial nominees. And I think that your credentials speak for themselves. I noted that you achieved the highest GPA at George Washington Law School, the highest in history.
Thank you.
Which is significant. And, of course, your clerkships, which have been discussed this morning, and you've held senior positions at the DOJ. You've spent years as a professor in constitutional and administrative law, and your list goes on and on. So speak for a moment about why you are ready, why this has prepared you to be a fair and unbiased judge.
Thank you so much, Senator Blackburn. And I'm deeply honored, of course, by President Trump's nomination to a seat on the Third Circuit and this committee's consideration. And as has been mentioned by some other senators and Senator McConnell, I've had the honor of being a public servant and working on all three branches of government, multiple positions there. Have been really grateful to serve for many years as a law professor, teaching students, some of whom are even working here today as committee staff. During that time, being able to file dozens of amicus briefs, sometimes on behalf of senators of this committee in courts around the country, in the Supreme Court, and then working as an attorney in the Department of Justice and now the White House on issues of separation of powers and testifying at this committee. And if I were to have the deep honor to be confirmed by this body, I would, in every case, bring exacting rigor and care and acknowledge the role of the judge as a very limited one in our system to resolve just discrete cases and controversies on questions that are brought before us where there's jurisdiction.
I wanted to talk with you a little bit, and you've written several pieces on the presidential constitutional authority to remove executive officers, and I noted your law review article in 2018, who are officers of the U.S., and I know that there is discussion around the president's ability to remove these officers from administrative agencies, and I know you can't talk about specifics, but talk generally about the state of the law when it comes to the president's constitutional removal power.
Thank you, Senator. And so as you mentioned, I want to be very careful sitting as a judicial nominee now and not as an academic in addressing issues that are in a very real way before many courts and many cases right now in the country. But as you've referenced, those pieces we're mentioning in the Stanford piece and then others, that the Constitution vests the executive power in the president. And it's by design because the president through the Electoral College is, of course, selected by the American people. And that if the president has the duty to carry out that power, the idea that that includes within it the supervisory power, and we would never want in our system of government anyone really to be exercising policy-making power who's not accountable back to the people. And so that just raises questions about if there are full tenure protections, whether individuals might be at some point too insulated from the political system and presidential supervision for it to be consistent with the constitutional structure.
Thank you. Thank you, Madam Chairman.
Thank you, Chairman. Professor Mascott, welcome. Is it fair to say that you have fairly little actual litigation experience outside of serving as amicus counsel?
Well, Senator, as I believe the Senate Judiciary Questionnaire points out, and also, actually, that was quite extensive experience, but dozens of amicus briefs, sometimes for senators here. I also mentioned the background.
Amicus brief is different than actually trying cases. Have you ever tried a case, for instance, to been the lead counsel in a case that was tried to verdict?
So, Senator, I believe is the letter that we submitted yesterday indicates, it was talking about the District of Massachusetts matter that I argued. That, it was the summary judgment and full trial collapsed into one hearing and argued that to verdict on the Title IX Department of Education, and then also had the honor to argue in courts of appeals during my time at the Department of Justice, and have served in all three branches of government, of course.
And with respect to your connections to Delaware, have you ever voted in Delaware?
Well, Senator, as I was discussing with Senator Coons, we, of course, have had a long time home.
Simple question. I'd prefer if I didn't get filibustered and I actually got an answer to a simple question. Have you ever voted in Delaware?
Well, Senator, as a public servant and professor here, no. I've been voting in Maryland.
Registered to vote in Delaware.
Well, Senator, as a public servant and academic here, I'm registered to vote here. If this body,
Driver's license or any other record of licensing from the state of Delaware?
Senator, I do not yet have a Delaware driver's license. I do have a car that is insured in Delaware with
Because you
the
have a summer
anticipation.
house there.
We've had a long time home, and yes.
And you were not admitted until May into the Third Circuit?
Senator, I became admitted in May in the Third Circuit, yes.
And you have no blue slip from either of the two Democrat senators, from Delaware senators?
Senator, I am really honored to be the president's nominee, and
Blue slip, correct?
well, I didn't believe there were blue slips at the circuit court level at this point for any circuit court nominees.
That was undone by our friends on the other side of the aisle, and now that is the new tradition, and I'm clarifying that you have none, correct, right?
Senator, I don't, because it's not been used for circuit court nominees.
Your nomination to the Department of Education as general counsel was withdrawn when? Today?
Senator, I believe it was referenced that it was yesterday.
Yesterday, okay. You were on the board of the New Civil Liberties Alliance, I believe, at the time when Jeffrey Clark was hired. Do you recall that hiring?
Senator, I don't know what you mean by recall the hiring. I was on the board of the New Civil Liberties Alliance and up through about July of 2021. And as I recall, what happened around that time is that, and I had a conversation with the director about it, I stopped being a board member. They were bringing litigation that involved an opinion that I had written at the Office of Legal Counsel in the executive branch, and I strongly disagreed with their stance in that litigation. It was actually bringing the opposite view. I also expressed that it was
about the hiring of Jeffrey Clark.
But that's I guess my point is, as a member of an advisory board, first of all, of the group, I wouldn't have had anything to do with it, and your issue has nothing to do with it.
You weren't aware of it?
I read newspaper accounts of his hiring on the New Civil Liberties Alliance. As a board member, advisory.
Nobody contacted you to ask that you support his hiring?
No,
You weren't consulted by him? You didn't interview him?
No, it was like a 24-member advisory board, a couple of dozen people, no.
Got it. You constantly use the pejorative term administrative state. You have called for the repeal or the overturning of Humphrey's executor. You have called to undo Chevron deference. You have supported the so-called major questions doctrine. All of these signals are extremely important to the fossil fuel industry, which has a decades-long battle against agencies that regulate its pollution, and which is the dominant donor interest to the Republican Party, and which heavily funded the $500 million enterprise to capture the Supreme Court. How on earth can you expect anybody representing an interest opposed to the fossil fuel industry to get a fair hearing from you?
Senator, if I were to have the honor to be confirmed at the Third Circuit, as mentioned, I would be holding the role of a judge, which is to resolve fully and impartially cases and controversies, not rule on policy matters. And also, just, if one looks at a record, even of amicus briefs in the clinics, these are cases that are being brought on legal principles, and at times for parties that are holding different policy views, and I would continue to have the same tradition of impartiality for the rule of law if I had the honor of being confirmed.
Senator Schmidt.
Thank you, Madam Chair. And I would actually, to follow up on Senator Whitehouse's argument, the little guy gets a better shot now. Look at the Loper Bright case. These were fishermen that through the administrative state were being then forced to pay for the own inspectors on the boats. And the leviathan of government that was aimed against them, including their pleas for help, were ignored. So I actually appreciate your position on as relates to the administrative state more broadly, but also your positions, I think, as the importance of separation of powers. And you're a national expert on that, and I'm very excited about your nomination, so congratulations.
Thank you, Senator.
Last year, of course, the Supreme Court overturned the Chevron deference doctrine, and you were gracious enough to participate in our post-Chevron working group, and I have the report here, which provides and outlines, I think, a way forward now that deference is no longer with us, thankfully. In your view, what is the importance of that Loper Bright decision?
Senator, I think it was quite a significant way in which the Supreme Court looked in that case at the text of the Administrative Procedure Act, which, as this body knows, governs procedural practices across administrative agencies, and simply underscored and reaffirmed the idea that when statutory text is before a court, the court's supposed to look at the text as it was enacted by this body and signed by the president, and not give a thumb on the scale in favor of the administrative agency's interpretation of the statute, because during the administrative agency's own regulatory proceedings, but take a full and fair look at what the law's text means.
So does any deference remain in interpreting statutory text?
Not on questions of law after the Loper Bright decision.
And you will faithfully apply that decision as a Third Circuit judge?
Yes, of course.
A couple other questions I want to get to quickly. At Catholic University's Columbus School of Law, you ran a Separation of Powers Institute, is that correct?
Yes, Senator.
Why do you think the separation of powers is so important? Why do you think, Justice Scalia once pointed out that a lot of dictatorial, even communist regimes have a parchment of paper extolling the importance of individual rights, but it's the separation of powers that ultimately allows that to be meaningful in this country. Why do you think it's so important?
Yes, Senator, it's core to our constitutional structure, because I think the framers understood that decision-making needs to be divided up among multiple people to keep those of us who want to serve and have power accountable ourselves. And so at the federal level, there's 3 different branches, as this body knows, but there's also the separation of powers vertically between the federal government and the states, and the policymakers are all accountable through elections back to the people, and it's core to our freedoms and our liberty and our prosperity.
And through that vertical and horizontal protection, it's meant to ultimately protect individual liberty, right?
Correct.
All of it
Yes.
is dispersed
Yes,
power,
Senator.
and yes.
Yes, absolutely.
I just, a couple final questions on a vertical stare decisis. In recent months, the Chief Justice, Justice Kavanaugh, and Justice Gorsuch have all emphasized the need for lower court judges to give some level of precedential weight to Supreme Court emergency docket decisions. And interestingly, many Democrat-appointed judges are refusing to do that. I heard a lot during the initial confirmation process from my Democrat colleagues about how they were so concerned that President Trump wasn't going to obey court orders. Well, it turns out district court judges appointed by Democrats with overtly partisan leanings are refusing to obey orders from the Supreme Court on questions that are 4 corners. There's no distinguishing. They just don't want to do it because they don't like President Trump. As a Third Circuit judge, will you respect Supreme Court precedent and emergency docket decisions?
Senator, yes, I will respect all Supreme Court precedent.
And do you have any issues with overturning a lower court judge who, on your read, did not follow Supreme Court precedent?
Well, Senator, I hesitate to say anything at all that would suggest I'm giving an opinion on a particular case, but as a general matter, I would consider myself on the appeals court to be responsible for following Supreme Court precedent myself, and if I saw it not followed in a decision that was under my review, to reach a holding that is consistent with the Supreme Court precedent and reverse the lower court.
So if a lower court judge were ignoring the Supreme Court, like my friends on the other side have wanted to juice up the public that President Trump would do, which he's never done, you would have the courage in that moment to say, to that lower court judge, you need to follow actually the Supreme Court precedent and ruling here.
If I thought a lower court decision was incorrect with that Supreme Court precedent, yes, I absolutely would reverse it and make it be, if I had jurisdiction, and make it be consistent with the Supreme Court precedent, yes.
Thank you, congratulations. I think you're going to be great on the bench. Thank you.
Thank you.
Senator Klobuchar.
Thank you. Thank you very much, Madam Chair. Issues have already been raised about Delaware, and I have a lot of respect, as does everyone in this room, for Senator Coons and his views of who should, his ability to weigh in on who should be a judge in his state. But I'm going to put that aside. I know that's been raised, and I'm very concerned about that. I want to lead with what Senator Schmidt was asking about, and that is the Justice Scalia's comment that our Constitution separates powers to prevent the centralization of power in one person or one party, because when power is centralized in one person, the game is over, that's his words, for rights. So President Trump has claimed, quote, I have an Article 2 where I have the right to do whatever I want as president, end quote. He said that as recently as on August 26, he said, I have the right to do anything I want to do. I am the President of the United States. Do you believe that the President is able to do, quote, anything he wants to do?
Senator Klobuchar, of course, it's not for me to comment on individual, statements really by anyone else. The matter of presidential discretion, as this body knows, within Article 2 in the executive power, there are a number of responsibilities that the executive has within which the executive has full discretion.
Okay. I'm just asking you if you think under our Constitution the president has the right to do anything, as he said, he wants to do.
Well, I suppose it depends. I don't know. I suppose it depends on the context of the remarks. Is kind of it was with respect my point. If we're talking about a pardon decision, if we're talking about nomination decisions, there are many ways in which the president has full discretion.
But you will not say that he doesn't have the power to do whatever he wants to do under the Constitution. He said anything he wants to do. He said the right to do anything I want to do. That's what he said.
Well, Senator, I guess I'm saying that presidential discretion depends on the context of the situation. You mentioned before separation of powers. Of course, also like we've talked about today, Congress has a lot of power.
You won't say it, so I guess the answer is clear. So last October, you told a group of students that you believe that, quote, presidents are actually too weak, end quote. That's at Yale. The president has unilaterally frozen appropriated funds, shuttered congressionally created departments, attacked the independence of the Federal Reserve and agencies Congress set to be independent, refused to put Democratic commissioners on independent commissions, imposed costly tariffs, detained individuals without due process, and gone after universities, law firms, and journalists. Do you still believe that, quote, presidents are actually too weak after these unprecedented power grabs?
So, Senator, without commenting on a lot of various actions and current issues that might be before the courts or currently are, my recollection of the context of the statement that you quote was that it was a conversation about presidential supervision of the executive branch, and at that time, my understanding of the Constitution, it remains to be that the president is vested with the executive power and therefore is in charge of the executive branch. And I believe I was making comments on that historically, as the Supreme Court itself has pointed out in different opinions, presidents have not always been free to fully supervise their branch. And I was putting forward a hope that the constitutional principles, as they are historically understood, would continue to be respected.
Okay, could we just move to guns here? As you know, we've had a number of horrific shootings in Minnesota this year, including involving assault weapon. So you have praised Justice Thomas's views on the Second Amendment, which are often in dissent, even on a very conservative Supreme Court. What is your understanding of the Second Amendment and whether Congress is permitted to pass laws to regulate the sale of guns? And I ask that because Scalia actually said, like most rights, the right secured by the Second Amendment is not limited. The right was a right to keep and carry any weapon whatsoever, was not a right to keep or carry any weapon whatsoever. And Thomas was the only one who struck down a law to stop domestic abusers from possessing a gun, legislation I worked on. He was also one of just 2 justices who would have struck down regulations of ghost guns. And in June 2025, he would have taken a case challenging Maryland's assault weapons ban. So what I want to know is, given that you've praised him, what is your view on your understanding of the Second Amendment and whether Congress is permitted to pass laws to regulate the sale of guns in any way?
So, Senator, I want to be careful, as in all my answers, of not straying into commenting on something that could come before me as a judge, but I agree with this, or would follow Supreme Court precedent, that there is an individual right to bear arms, and that in looking case-by-case basis, it's important to look at the history and tradition of what the regulation of guns was at that time. And so if a case came before me raising that question, I would faithfully and fully apply Supreme Court precedent.
Thank you. I'd like to enter a letter into the record from 53 legal scholars. They write, quote, "We are united in our view that Professor Mascott would be an outstanding addition to the federal judiciary. Professor Mascott's impressive legal career includes service in all 3 branches of the federal government, in private practice and in the legal academy. Her work has been cited not just by many scholars, but by judges at every level of the federal judiciary, including the Supreme Court. Some of us agree with her analysis, others do not. We agree that, on the whole, Professor Mascott's academic work demonstrates the sort of intellectual rigor and depth that will serve her well during her career as a judge," end quote. Thank you. Senator Welch.
Thank you very much, Madam Chair. Professor Mascott, the Congress has authorized the creation of inspectors generals, and in fiscal year 24, it saved 71 billion. In fiscal 23, it saved 93 billion. Is it your view that Congress has the authority to establish inspector generals that review the appropriations and expenditures that Congress authorizes?
So, Senator, as with all the questions, I want to, in answering, stick with general principles in case there would ever be a case before me raising questions related to inspectors general. I don't understand there to have been a general constitutional question raised about inspectors general. I mean, I think with respect to the question about their role in the system, as I mentioned in prior discussions on executive power, it would always, of course, be important that the office is structured so that that position is ultimately under the supervision of the executive branch, and ultimately the president. I realize that raises constitutional tension with the role of the inspector general to look at records.
There is a tension, okay? The Congress clearly has the right to appropriate funds, correct?
Yes, it's a constitutional power, of course, to appropriate funds.
And in the power to appropriate funds, do you contest the obligation that Congress has to make certain there's oversight in the expenditure of those funds?
Well, Senators, as the Supreme Court's indicated in precedent in the last couple of years, part of Congress's legislative power, yes, includes the ability to get records and to find out what's happening in the agencies that it legislates.
You have some question as to whether Congress, in pursuance of that obligation to oversee the wise use of taxpayer money according to appropriations Congress made, that Congress can't have an inspector general that is doing that work for us on a daily basis on behalf of the American people?
Oh, I certainly think Congress can create an office that is responsible for accounting and keeping records and can ask for records.
The executive has fired the inspector generals, correct?
Well, I don't, as a factual matter, I don't recall how many firings there have been. My question also said it needs to be subject to.
It doesn't matter how many. The executive has fired without giving Congress the 30-day notice required in the statute.
So, but Senator, my earlier question, and again, now we're starting to get into the kind of specifics of things that could come before me if I were a judge. But
well,
in general,
specific.
Even inspector generals, anybody who is responsible for any portion of the executive power has to be responsible to the president, and it's because of the core value in our system of elections.
But that's the tension. We have a responsibility in Congress to appropriate funds, correct? We have a responsibility to make certain that the funds that are appropriated and paid for by the American people are wisely spent. Do you have a dispute with that?
Senator, you do, but with respect, when we're talking about Inspector General, which is in your hypothetical, is an
I'm going to interrupt for a second because we're not getting an answer here. And I'm acknowledging there is a tension, but it goes back to what Senator Klobuchar said. There is a tension because in the constitutional system, it was designed to have a tension so that there wouldn't be the concentration of power in one branch, the executive, the legislature, or the judiciary. Let me ask another question. If Congress has the authority to impose tariffs, and that is a constitutional responsibility and right we have, is that correct?
Yes, Congress has legislative responsibility for
So does the
taxing,
executive
yes.
have the legal authority to impose a tariff because the executive doesn't like what the judicial process is doing in a country like Brazil?
Senator, the question of tariffs is
No,
actively before the
I'm
courts.
not asking just about the tariffs. I'm asking, is there constitutional authority for an executive to decide to use the tool of a tariff because he disrespects and dislikes a judicial policy in another country?
Senator, my understanding of the legal basis for the tariffs is statutes that this body enacted with broad discretionary language, and tariffs within the terms of those statutes would of course be lawful.
Last question, who won the 2020 election?
Senator, President Biden was certified the winner of the
You can't
2020
tell me who won.
election. Well, Senator, President Biden was certified the winner of the 2020
Did he
election.
win the election, or did it just accidentally get certified?
Senator, I've answered that question. He was certified the winner of the election.
I yield back.
Senator Schiff.
Thank you, Madam Chair. Professor, you've appeared before the committee many times, but the last time you were in committee was for a hearing entitled, "When the President Does It, That Means It's Not Illegal, the Supreme Court's Unprecedented Immunity Decision." At the time, you described that immunity decision as modest, and I want to ask you about the modest impact of that decision. When John Sauer was here for his confirmation hearing, I asked him about an argument he made in that case before the Court of Appeals, in which he was asked specifically by the Court of Appeals judge, one of them, if the president were to order SEAL Team 6 to assassinate a political opponent, would he be immune? His answer apparently was yes, unless the president's party was willing to impeach him first. Is that your view as well? Would he be immune from prosecution for using the military to assassinate a political opponent?
Well, Senator, as a lower court judge, I'd be fully bound by Supreme Court precedent. On that particular question, and this is one reason I address the opinion as modest, the opinion addresses only portions of presidential immunity. It specifically is addressing criminal immunity.
I've asked you a specific question. Would the president be immune from prosecution if he ordered SEAL Team 6 to assassinate a political opponent? No.
Senator, under the Supreme Court precedent on that question, the Supreme Court has specifically not answered it.
Is that a difficult question? Is that an open question in your view?
Well, Senator, under the contours of Trump versus United States, which deals with criminal immunity, I'm not sure that it fully answers all of the political mechanisms that would be in place to address and keep such a horrific situation from ever occurring.
So you're unclear as to whether a president could be prosecuted for that. Is that what you're saying? You don't know the answer?
Well, I think what I'm saying is that within the particular contours of criminal immunity discussed in that opinion, it addresses actually what is an official act. And so I think the first threshold question would be whether one could ever conceive of such a thing as an official act.
I don't want to filibuster my question. It's very simple. If the president tomorrow to order SEAL Team 6 to assassinate a political opponent, in your view, is he immune from criminal prosecution absent an impeachment first?
If it's not an official act, a phrase that has not yet been fully
If he's
defined in the
using the
courts,
military to do it, which the court said he has absolute immunity when he deploys the military, is he immune or not?
well, I don't read the court's decision to say that any use of the military outside of official acts comes within its immunity contours. And as this body knows, because of various drone strikes and other
Under the
things.
question I asked you, what's the answer, Professor, yes or no? You're used to
Senator-
answering questions and asking your student questions. I'm asking you a very simple question, yes or no. Is the president immune if he uses SEAL Team 6 to kill a political opponent?
Senator,
Yes
with,
or no?
with respect, I
Okay,
think the Supreme
with
Court.
respect, you're not willing to answer the question. Let me ask you a different question. It was recently reported that the president and his family made around $6 billion from the sale of crypto assets. Some of that money, much of that money, comes from the Gulf. If the president were to sell a foreign policy decision to a Gulf nation in exchange for a crypto donation, is he immune from prosecution for that?
Senator, I don't know anything about the situation that you are describing.
Well, but
As
you,
I have
but you
said,
know something about the immunity decision. You said it was modest. I'm trying to determine just how modest you think it is. Can the president sell U.S. foreign policy to the highest crypto donor and have a get-out-of-jail-free card?
Senator,
Or is he liable for prosecution?
Senator, if I may, the Constitution has many constraints for all of us
You
to
don't want
carry it
to. You
out.
don't want to
Well,
answer that
well,
question. Let me ask you a very different question. If the president were to use the military in direct violation of court order, deliberately, knowingly, blatantly use the military in violation of court order, is he immune from any liability?
Senator, as I said when I testified last September about the decision, the Clinton administration had an
I'm
opinion.
not asking about the Clinton
Well,
administration.
but it's directly relevant, that a president, the position of the Clinton administration is that the
I'm
president,
not
while
asking the
serving.
position of the Clinton administration. I'm asking your position, your view of the immunity decision, which you've described as modest. I'm trying to determine just how modest you think it is. You're
So-
unwilling to say a president can't kill an opponent and be liable. You're unwilling to say the president can't sell foreign policy of the United States for cryptocurrency. You're unwilling to say he can't do that and still be immune. My question is, can he use the military in deliberate violation of court order and be immune, yes or no?
Senator, you're asking very specific questions about whether our criminal justice system is the
Madam Chair,
forum to
I yield
punish.
back.
Thank you. I'd like to enter into the record a letter from 48 former Justice Department officials that are familiar with Professor Mascott's work. They explained, quote, her academic scholarship has been cited in Supreme Court opinions. She has argued high-stakes federal cases, and she has submitted scores of briefs in courts across the country. Mrs. Mascott has been a world-class mentor to hundreds of aspiring lawyers. She was also a standout attorney at the Department of Justice, and her judgment is beyond reproach. She will make an excellent judge, end quote. Without objection, the letter is entered into the record. Senator Booker.
Thank you very much, Madam Chairman. And Ms. Mascott, this doesn't directly pertain to you, but I just want to say for the record, I'm watching in the short time I've been in the United States Senate the continued deterioration of the advise and consent role of the United States Senate. I know Senator Coons very well, as one of my few friends I had in the Senate before I became a senator, who works in a bipartisan way, in a way that's a model really for the United States Senate. He made it very clear to the White House he was willing to work with them to find a candidate acceptable to them that could be a consensus and unifying candidate. But unfortunately, they are strongly objecting to your nomination. And I know, and I've heard from members of this committee on the other side of the aisle, how much they reacted when a similar situation happened, or at least what a nominee was put forward in the Biden administration that didn't ultimately go forward to a vote. Well, this mirrors my experience with the vacant Third Circuit Court seat in New Jersey, which was filled by Emile Beauvais. With your nomination, we now have 2 judicial nominees to the Third Circuit that do not have home state senator support. But more than that, their objections, I think, are principled because of your lack of ties to the circuit On the appellate court, you will be reviewing decisions of the district courts in Delaware, New Jersey, Pennsylvania, and the Virgin Islands. You have appeared in this circuit and have very few ties. There's a reason why our framers put these very important pillars into our Constitution. And what I'm seeing right now is something that I know confidently that my colleagues on the other side of the aisle would not accept, would find problematic. And to do it in a district where there are senators who are very much willing to support Republican nominees that are done in a process that brings us together and doesn't yet again not only divide us, but ultimately continues to deteriorate the role that we have, I find highly objectionable. But Ms. Mascott, you are before us, and I want to jump right in. In your Senate questionnaire, you describe your selection, when the president tried to fire FTC commissioners, I believe illegally so, Rebecca Slaughter and Alvaro Bedoya, I led over 40 of my colleagues in an amicus brief before the court. In our brief, we defended the statutory protections Congress gave to the FTC commissioners to prevent a president from firing an FTC commissioner without cause. These protections were upheld by the Supreme Court in a 100-year-old precedent, almost 100-year-old, the Humphreys executive decision, which I know you're familiar with. These protections exist because we need the FTC and other independent agencies to remain independent. The FTC breaks up monopolies, protects children's privacy online, it protects consumers by encouraging competition that keeps prices low at the grocery store, the pharmacy, and gas stations. But you argued that Humphrey's executive was, quote, not correctly decided. You were arguing essentially that independent agencies, that the FTC, maybe even the Federal Reserve, were never meant to be independent and shall serve at the pleasure of the president. Can you explain how an agency tasked with protecting American consumers can possibly remain independent if a president can fire its members at will for any reason?
So, Senator, thank you for the question, and I want to be careful in giving an answer. I know you referenced some of my academic writings to not stray into definitive statements that would be a problem as a judicial nominee. Structurally, with constitutional principles, my scholarship and those comments are referencing the principle that the president is vested with the executive power and so needs to be fully in charge of the executive branch, and that within our system we have checks for everyone. And so if there were a fully independent commission, who would be responsible for checking their actions if it's not the presidential supervisor? Now, certainly Congress, through its appropriations power, through the contours of the power that it gives to the office, through imposing constraints, would certainly have a role. And so I think that's a way in which the separation of powers would operate effectively.
So I'm going to have more questions for the record, but I want to just let you know clearly that I believe we have a president who has authoritarian ambitions. I believe we have a president right now who is openly violating court orders, openly violating clear principles of our Constitution. I have a president that is threatening judges that disagree with him and the independence of the judiciary. We have a president that is assuming responsibilities like spending powers clearly laid out in the Article I branch. I'm doing a lot of reading recently about the deterioration of democracies around the globe. And it is amazing how this president is doing things that speak to a very chilling and very sobering reality of a person who does not have respect for our Constitution and is doing things to me that could undermine our democracy, its strength, the trust in our institutions, or worse. I have a big suspicion now that he is putting forward judges that are more loyal to him than they are to constitutional principles. I believe we are in a dangerous time. And I'm going to have questions for you for the record, but I will say to you in this open hearing that your job is not to be President Trump's lawyer on the courts, but it is a sacred obligation. And when the independence of agencies, when the checks and balances of our Constitution are under attack as they are right now, it really is chilling to me that we have a judge nominee before us that cannot state unequivocally that they will protect not just the Constitution, but the important and urgent independencies of agencies and the urgency we have right now to deepen our commitment to constitutional principles. And so I look forward to getting your answers on the record, and thank you very much for the indulgence to the chairman.
Thank you. Professor Mascott, you have had a lot coming at you. Want to say congratulations on your nomination and wanted to give you the opportunity to think if there are any questions that you'd like more time to answer or to dig into. I certainly would love to hear those responses. I know how these back and forths can be, and certainly we'd love if there's anything that you didn't get to address to give you that opportunity to do that. But when I'm looking at your background, graduating from law school with the highest GPA ever recorded at George Washington University Law School, clerked for 2 justices on the Supreme Court, and authored 29 published scholarly papers with a combined total of over 5,700 downloads. You and your work have been specifically cited by justices of the Supreme Court, both in written opinions and oral arguments. We've heard some today about your time in academia. What I think people need to understand is that you have not retreated to the ivory tower of academia. Unlike most law professors, you clearly kept one foot in appellate practice, and then the other filing amicus briefs, obviously inconsequential appeals before the Supreme Court and federal courts of appeals, and also being there in the classroom. Supreme Court justices have even mentioned you by name at oral arguments, spotlighting the position that you've advanced in an amicus brief. You've also stood in federal court on behalf of the United States and authored scholarship that Supreme Courts have cited 8 times, underscoring your contributions to these courts and scholarly understanding of all that is in front of us. That blend of practice, appellate advocacy, and scholarship, all while juggling the demands of being a professor, are rare and exceptional. Would love for you to take a few minutes and talk a little bit about how you believe that has shaped your judicial philosophy, and then also would like to hear anything that you feel like you haven't had an opportunity to answer.
Well, thank you very much, Senator. And I've been really honored to serve in all of those venues. And if this body were to do the honor of confirming President Trump's nomination to the Third Circuit, I would, of course, carry out that duty with a lot of seriousness and rigor, upholding the rule of law to the best of my ability, impartially, according to the text and structure of the Constitution. And the opportunity to serve in all 3 branches of government has really helped to provide experience that I think would give a good foundation of being able to understand the limited role of a judge. And as far as more comments, I'm just very grateful for everyone's time this morning, and am just really so thrilled and moved to think about the possibility of continuing to be able to serve this country if I were confirmed to the judiciary.
Well, thank you for your willingness to serve. This concludes panel 1. We appreciate your testimony, Ms. Mascott, and you are excused.
Thank you.
Will the witnesses for panel 2, the nominees, please come forward and stand at the witness table? I will now administer the oath. Would you all raise your right hand, please, and answer this question? Do you swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you very much. You may be seated. Well, welcome. And as customary in our process, if you desire to introduce the people that are with you, including your family, then you may be able to do that and then give your opening statement. We're going to start with Justice Chamberlain, and then we'll just go right down the line. Justice Chamberlain, the floor is yours.
First, I would like to thank Chairman Grassley, Acting Chairperson Britt, and Ranking Member Durbin I appreciate you and the members of this committee for holding this hearing. I would like to thank President Trump. It is a tremendous honor to receive this nomination and to be here today. I would also like to thank Senators Wicker and Hyde-Smith for their kind remarks earlier this morning. I've known each of them for many years, and I greatly appreciate the kind words. I have with me today my wife, Kim. We just celebrated 33 years of marriage not very long ago. She herself has been a public servant for decades, and importantly to me today, she has stood by me during any endeavor I have undertaken, and I've tried several during my career. I would like to thank a few people or mention a few people that are not here today, but that are viewing from home or otherwise. My mother, she would not, she's back home in Hernando. She would not miss this for anything in the world other than her irrational fear of flying, which I believe is the same reason my mother-in-law is watching from home. I'd like to recognize my brother Larry and his my sister-in-law Juanita, who are both doing the same, as well as my brother-in-law Don and my sister-in-law Sydney. Finally, I would recognize my son William and my daughter-in-law Sarah. They are back home in Jonesboro, Arkansas, where they work for Arkansas State University. Him in the athletic department, her in communications, and they are getting ready for their first ever matchup against the University of Arkansas in football. And as you know, in the South, football is king. I would briefly mention a couple of mentors, if I may. I would mention Bill Austin, who gave me my first job back in my hometown. He and the law firm, Billy Myers, Mary Monty, Debbie Brandon, each taught me many, many things in their own way about the law, and I'm greatly appreciative of Bill Austin for taking me under his wing. But I also like to mention my aunt, Jeanette Martin. She was the political member of the family, and she taught me that it doesn't cost anything to be nice to people. That's right. And finally, I would like to give a short dedication at this hearing to my oldest and dearest friend who passed away unexpectedly a month ago. If you knew Louis Smith, you would love him, and I want to dedicate this hearing to him. I thank you each for this honor, and I look forward to answering your questions.
Madam Chairwoman, he mentioned an extraordinary wife. I just don't know of all the incredible women that are out there who it is. Can she identify her? There she is.
And also congratulations on your incredible news, speaking of outstanding wives.
I don't know about the judge and his qualifications. I'm looking forward to reading more about him, but I do want to know how you keep a woman that's much better than you and stay married to her. So I look forward to
He just got engaged this weekend. It's a whole thing.
Congratulations.
Thank you very much.
And I outkicked my coverage.
I did too, sir. As a football player, former football player, as the chairwoman's husband, I know what that means.
Yeah, congratulations, Senator Booker. Mr. LaCour.
Thank you, Senator Britt. Thank you to Chairman Grassley, Ranking Member Durbin, other members of the committee for having this hearing today. I'm deeply honored to be here. I'd like to first thank Almighty God, to whom I owe all good things. I'd like to also thank President Donald Trump for the great honor of this nomination. I've got a few people to thank, including my lovely wife, who I think was taking my boys out on a little tour of the Senate. She should be back momentarily. Thank you as well to the dear friends of ours who are keeping our two younger and noisier children while we were up here in DC. We love you all very much. Thank you to the many family and friends who are here present and also watching from afar, especially to my parents who always instilled in me the value of developing my talents to serve others and who made so much of that possible for me. Finally, I'd like to thank many former colleagues and current colleagues of mine who helped and shaped me as a lawyer. Past colleagues at Baker Botts, Bancroft, and Kirkland, as well as my current colleagues at the Alabama Attorney General's office who've set the bar so high as a lawyer or as lawyers and helped me to reach it. Thank you to the judge I clerked for, Chief Judge Pryor, who has been just a phenomenal mentor and example as a man and a jurist. And then finally to Attorney General Steve Marshall, who gave me the opportunity to serve our home state and has supported me in so many other ways since then.
Yes, and your wife and boys have entered the building.
Hi, Dave.
Justice Lewis.
Thank you, Madam Chair. Thank you, Madam Chair. I can't tell you what an honor it is to be before this committee. As a political science major, I am very happy right now. Also, Ranking Member Durbin, Senator Grassley, thank you for allowing me to be here. I'd like to thank President Trump for the nomination. I'd like to also thank Governor Ivey for supporting me in my role as a state judge. And I'd also like to thank the people of Alabama who have pretty much unanimously supported me throughout my political career. We have a lot of brothers and sisters in my family, so in the interest of time, I won't introduce all of my family specifically. But all these folks in church on the front row here are my family, and I am honored to have them here, as well as my many friends and colleagues and even employees. Thank you.
Thank you very much. Justice Maxwell,
Am I on?
you are.
Senator Britt, Chairman Grassley, Ranking Member Durbin, members of the committee, I want to thank you for holding this meeting here today, and I want to give special thanks to Senators Hyde-Smith and Senator Wicker for their kind words and their support throughout this process. And I want to thank President Trump for the nomination, for that honor. It's been a dream of mine to serve on the federal bench in the Northern District of Mississippi. They told us to keep our remarks brief, and I'm going to try to do so. But I do have a few family members to recognize and some special guests. And the first one, of course, that I want to start with is my wife, Mindy Maxwell, who actually met in the federal courthouse for the Northern District of Mississippi while I was in law school.
There you go.
And we've been married now for 23 years. And I want to say this to Senator Booker. I can tell you beyond a shadow of any doubt that when the good Lord put Mindy Maxwell on this planet, he didn't create another woman like her, and she's been a very special wife, wonderful to me, and a terrific mother to our children. She's also a consummate professional, and you know, she's also my best friend, and I know that, and I congratulate you on your wedding, and I hope that you have that same experience that I've had with my wife, Mindy. Senators, I wish that my kids were here today for you to be able to meet them. They're both in college, hopefully in class right now. My daughter, May, is a sophomore at Justice Lewis's alma mater, Swanee, in Tennessee. And my son, Tripp, is playing football. He's a quarterback. He's a redshirt sophomore, kind of near Ural stomping grounds. He's out in California playing in Los Altos at Foothill Community College. At least he was last night when I checked with him. I don't know if he's hit the portal today, which is definitely a possibility. Moving on from that, Senators, my mother, B.B. Maxwell, was not able to attend today. She would have loved to have been here. I know she's watching on TV from Durham, Mississippi, population of 900, probably on her knees praying for me like she has done for most of my life. My sister Amanda is watching from Houston, Texas, and I have some special guests. My law clerk, Beth Archer, is here. My judicial assistant, Ellen Ford, is here, and one of our family friends, Blake Neely. Before I conclude and close, I want to say a few words about somebody who is no longer with us, but who has been a mentor throughout my life, and that's my father, Jim Maxwell. He was a trial lawyer's trial lawyer. My rides to school as a kid were a little bit different probably than most others. I didn't get to control the radio. He did, and he played tapes of the greats, Racehorse Haynes, Melvin Belli, Mo Levine, Percy Foreman, and later on Jerry Spence. Looking back, I hated it at the time, but right now, I'm glad he didn't change that dial. Senators, just in closing, I want to thank you again for this opportunity. I look forward to answering your questions.
Thank you. Mr. Moody.
Senator Britt, Chairman Grassley, Ranking Member Durbin, members of the committee, thank you for this opportunity to appear before you today. I'd like to begin by thanking President Donald Trump for the honor of nominating me to the United States District Court in my home state of Alabama. To Senator Tuberville, thank you for those kind words during the introduction. To Senator Britt, God is good. More than anyone else, it's been your tireless service to this country that inspired me to answer the call to serve. Thank you. I'd like to first, for 17 years of private practice, I could spend all morning taking up too much time thanking everyone. I just want to start with my family. My mother and father are both here from Montgomery, along with my brother. My father taught me what it means to be a lawyer and how to treat other people with respect. And I know my brother has learned similar lessons practicing law with my father. My immediate family from Huntsville is here. My lovely wife, beautiful and also a practicing attorney, and our 2 middle school-aged children are here from Huntsville. And so many others made the trip to D.C. to support my nomination. I'd like to thank them for making the trip, and also thank you to those who are watching remotely for also supporting me through this process. Senator Britt, thank you again, and I look forward to answering the committee's questions.
Thank you. I'm going to reserve my time for later in the hearing. And Senator Durbin, I'm going to go ahead and kick it to you.
Thanks, Senator Britt. Appreciate it, and thank you all for being here. I apologize for stepping away, but Senator Grassley and I were actually on the Senate floor conducting some business relative to the committee, so we were not taking lunch breaks. We were busy during that period of time. Mr. LaCour, you were Solicitor General for the state of Alabama, is that true?
That's true, Senator.
And there came a time when you were involved, I believe in 2023, in the drawing of maps for, were they legislative or congressional districts?
Senator, that case is still in active litigation, and I am an attorney for my client, so I want to be careful not to tread on any privileges. But there is some evidence that came out in litigation that state lawyers were advising state officials on issues of state law, which is something that the Attorney General's office in Alabama and in many states does do with pending legislation.
Could you clarify, were these legislative districts or congressional districts?
Sorry, Senator, these were congressional districts.
Okay. And the case is still pending?
Yes, Senator, we have appealed to the United States Supreme Court.
Public reporting and testimony revealed that you played a significant role in working with the state legislature to create maps that continue to disregard federal court orders and suppress the influence of black voters. Would you like to comment on that?
Senator, yes, I would like to say, again, we have arguments that we advanced in the case as to why that 2023 map is consistent with Section 2 of the Voting Rights Act and with Equal Protection Clause's demands that states not use race to sort voters into different districts. And when it comes to defiance of court orders, I don't think any court order has been defied in that case. There was a court order in 2022, back in January, a preliminary injunction entered against our earlier 2021 plan, and that order was complied with to the point where we got a stay from the United States Supreme Court.
I hate to interrupt you, but I'm going to ask this specific question so that we get to the heart of this. State lawmakers said you helped draw the new map as Solicitor General in a room across from state legislatures. You pushed for the inclusion of so-called legislative findings and helped write talking points for them. Are you aware of that assertion?
Senator, I'm aware of that evidence and those allegations.
True.
Senator, all I'm going to say is what the evidence shows in the case, because again, I'm an attorney that is still litigating and are privilege issues that I do not want to overstep.
In the case of Allen versus Milligan that went before the U.S. Supreme Court, I understand in 2022, you argued that Section 2 of the Voting Rights Act required evidence of discriminatory intent to prove a violation. Do you understand now that that is different than what the law says?
Senator, we presented several arguments in that case. I think the Supreme Court has agreed that intent is not irrelevant under Section 2 of the Voting Rights Act. In that case, we presented an argument that was similar to one that Frank Easterbrook had adopted for the Seventh Circuit, that if you're trying to determine whether a map is dilutive, it's helpful to have a benchmark, dilutive compared to what? And we had argued that if a plan that is being attacked under Section 2 of the Voting Rights Act looks like a map you might expect from a race-neutral process, then it's not discriminating against anyone on account of race. Ultimately, the Supreme Court, by 5-4 vote, did not adopt that particular argument, but the litigation continues.
Judge Lewis, you've been on the bench since 2016. The Alabama judicial canons state that, quote, it is desirable that a judge or candidate for election to judicial office endeavor not to be involved in the internal workings of a political organization. You have served as a member of Executive Committee of an Elmore County political organization since 2006, including chairman since 2018, and the state party's Executive Committee since 2008. Why did you not follow the recommendation of the Alabama judicial canons?
Senator, it is a recommendation, but I also checked with the ethics and, of course, the JIC, which is our regulatory agency, and they permitted me to do that.
Pardon me, who permitted you?
The Judicial Inquiry Commission, JIC, is our regulatory body. And we run partisan elections in Alabama. I'm an elected official, so that was kind of a segue into my political career.
Thank you. Senator Britt, I'd like to have an additional 60 seconds if you don't object.
Absolutely.
Justice Maxwell, in Nash versus State, you upheld a 12-year sentence for a defendant convicted of a misdemeanor, 12 years, convicted of a misdemeanor for possessing a cell phone while in jail. You wrote, and I quote in that decision, while obviously harsh, the sentence is not grossly disproportionate. 12 years in prison for a misdemeanor possession of a cell phone. Please explain.
Senator, first, I would like to clarify that I was not the trial judge in that particular case, and this was not a misdemeanor charge. It was a felony offense that was charged by the district attorney, and our role as the Mississippi Supreme Court was to decide whether that was a lawful sentence within the parameters set by the legislature, and it fell within the parameters that were set by the Mississippi legislature, and it was a 9-0 decision by our Supreme Court on that question, whether it was a lawful sentence.
The defendant had a wife and 3 children that depended on him, had been staying out of trouble with the law for nearly a decade since his prior conviction. The crime was victimless, and the facts suggested his crime was accidental and likely caused by a failure in booking procedures. And yet you thought 12 years for a misdemeanor was warranted?
Senator, I did not impose my personal thoughts about that particular sentence. What I did was follow the letter of the law.
But the range, what was the range of sentencing in that?
The range was up to 15 years in
From
prison.
what low number? 6 years, right?
I don't remember the minimum range. We were just looking
I think
at
it was 6.
whether it was within the parameters.
12 years for possession of a cell phone. Thank you, Madam Chair.
Thank you, Senator Durbin. Senator Kennedy.
Thank you, Madam Chair, and congratulations, gentlemen. I thought I would just start down here and then move this way, if that's okay. Judge, what is the rational basis test?
Senator, I believe the rational basis test is going to be one of your least stringent tests, and whether a law has a rational basis for the outcome intended or the governmental interest that you're trying to obtain.
Okay. What if the legislature or the Congress, as the case may be, doesn't list a reason? What if they just pass the statute?
Senator, I would submit that probably happens many times, and I think it's the role of the court when determining such matters as a definition. I think it's the role of the court to determine whether the usage of that statute, using its wording in plain meaning, whether the usage of that statute is going to reach the governmental interest that you hope is obvious, but sometimes you have to determine.
So you just create the basis, the reason for the statute?
I don't think that you create it, Senator, but I don't think that most statutes, to be honest, I don't think that they tell you what they are trying to accomplish so much as they say, this is the law. For example, possession of a narcotic that's going to say it's illegal to possess this. We determine if there's a rational basis that forwards the ends of the governmental interest.
Well, how do you determine if there's a rational basis? Do you look at the statute or do you look behind the statute?
Well, I think that you always look at the statute. Now, I think you also look at any other precedent or case law that has interpreted the statute. However, you look to the language of the statute to determine what it does and what effect that might have.
Okay. Counselor, let's suppose that that a legislature passes a statute that says if you have a college degree or a more advanced degree, you don't have to take a driver's license test. And let's suppose that assume for a second that the federal court has jurisdiction over a challenge to the constitutionality of that test, of that statute, rather. What test are you going to apply, Counselor?
Senator, that would be a classification that doesn't turn on any sort of protected characteristic, and so it would be a rational basis test that would apply in that instance.
You don't see any suspect classification?
No, Senator.
You don't see any fundamental right?
No, Senator.
Okay, what if the legislature didn't provide, so you would use the rational basis test?
I would, Senator.
And you would uphold that statute?
I think there could be some rational basis that a court could conceive of to justify that statute, and rational basis is not.
So you would invent the rational basis, the reason for the statute?
That's generally how the test has been applied by the Supreme Court and by lower courts, and as a district court judge, I would be bound by that Supreme Court precedent.
Okay. Judge, tell me the difference, sir, between notice pleading and fact pleading.
Notice pleading, of course, goes to your due process issues under the 14th Amendment.
But what's the difference between notice pleading and fact pleading? We use two systems in America, as you know.
Yes, sir. Notice pleading is based on, of course, that goes into your jurisdiction, your personal jurisdiction, and then the fact pleading, of course, goes into your subject matter jurisdiction.
What system does the federal judiciary use, notice or fact?
No, fact.
Okay. Judge, I'm about out of time. Can I have 30 more seconds, Madam Chair? You heard me talk to the nominee for the Third Circuit about how she would interpret the Constitution, and she said that the Constitution should be interpreted according to its meaning as understood by the people in America at the time the Constitution was passed. Do you agree with that?
I do, Senator.
Okay. Let me ask you what I asked her. How do you square that with Brown v. Board of Education?
I would adopt a lot of what she said, actually. I believe the 14th Amendment, as it came in, addressed.
14th Amendment was later.
It was later. It was a reconstruction.
Can you turn your microphone on, please?
Sorry
Thank
about
you.
that. I believe that Brown versus Board of Education is correctly decided.
I do too, but when my friends, and I'm a textualist as well, but when my friends say, well, we have to interpret the Constitution in accordance with the way the average American viewed the Constitution at the time. I say, okay, that seems fair to me. Do you think that the average American at that time looked at the Constitution and supported and believed that it provided for racially integrated schools? Do you think that was a majority view at the time?
Senator, all I know is that Brown versus Board of Education is good law, and it was correctly decided.
And why do you think it was correctly decided? I agree with you, but why?
Well,
if you interpret the Constitution by looking at its public meaning at the time.
Separate was not, it was inherently unequal, not equal.
It was what?
I just don't believe that there's any appetite in this country for any type of de jure type of segregation. I believe
At the
that
time
case.
the Constitution was passed?
I'm talking about right now. I believe that it's good
No,
law,
but
Senator.
okay. I've gone way, way over. I'm sorry, Counselor, I didn't get to you.
No problem, Senator.
Senator Blumenthal.
Thanks, Madam Chair. Let me follow that line of questioning by asking all of you, do you think Brown versus Board of Education was correctly decided? We'll go right down.
Senator, I believe as a general rule, it'd be improper of us to comment on the validity or give a thumbs up and down to most opinions. However, it's been traditional among the nominees that have come before this committee regarding Brown versus Board of Education, and I will follow that and state my opinion, which is I believe it was correctly decided.
You do believe it was correctly decided?
Yes, sir.
Senator, I agree with what Justice Chamberlain just said. Yes, Brown v. Board was correctly decided.
Thank you.
Senator, I am very thankful for Brown versus Board of Education. I do believe it was correctly decided.
Same answer.
Same, Senator. I do believe Brown v. Board was correctly decided.
Thank you. Let me ask then each of you, do you believe that Loving versus Virginia was correctly decided?
Senator, I would preface with the same comments about commenting on cases, but I think for the same reason a moment ago that there are two cases, Brown versus Board of Education and Loving versus Virginia, that have been commented on regularly, and I will maintain that tradition and state I do agree with that opinion and believe it was rightfully decided.
Thank you.
Yes, Senator, as a beneficiary of interracial marriage, I also agree Loving Virginia is correctly decided.
And yes, Senator, again, I think there's been precedent from prior nominees that those two specific cases we are able to comment on, and I do believe it was correctly decided.
Senator, I believe it was correctly decided.
The same, Senator. I do believe Loving versus Virginia was correctly decided.
Let's go to another case, Obergefell versus Hodges.
Senator, as I began a moment ago when you asked about Brown versus Board of Education, I would first say it's improper to comment on whether these decisions were wise, and our opinion as lower court judges below the Supreme Court, of course, I think it would be improper for us to comment on that. I did make exceptions for two cases because that has been traditional before this committee, but I do have to limit it to that and will be unable to respond to the question.
So on what basis do you distinguish Brown versus Board of Education and Loving versus Virginia from Obergefell? They're both well-established, long-accepted precedents of the United States Supreme Court. You think that Loving and Brown were correctly decided, but you're unwilling to comment on Obergefell?
Senator, I simply distinguish those because it has been traditional among nominees to respond regarding Brown versus Board of Education and Loving versus Virginia.
Well, I wouldn't say, if I may interrupt with all due respect, I wouldn't say it's traditional. I've just been asking this question for the last couple of years, and that happens to be the way nominees respond. They're willing to comment on Loving and Brown, but not on Obergefell. We can go on to Griswold. There's no tradition here. I'm asking you, as an individual and a nominee for the United States District Court, do you think that Obergefell was correctly decided?
Well, Senator, as I said a moment ago, it is the better practice not to comment on the wisdom or correctness of these decisions. As you just stated, it's been asked about these cases for a period of time, and I'm merely following the line of tradition in answering the cases regarding Brown and Loving.
So essentially, and again, I don't mean to say this with any disrespect to any of you, you're just doing what's worked for the previous nominees.
No, sir, I'm just following what they have done, as I felt those are answers that have been acceptable.
I'll give others the opportunity to comment on Obergefell as well.
Senator Obergefell is binding precedent of the United States Supreme Court, and I would apply it faithfully if I'm so fortunate as to become a federal district court judge.
Do you think it was correctly decided?
Senator, just like Justice Kagan and Justice Jackson and other nominees who appeared before this court, I would not want to be seen as giving a preview as to how I might decide any related case, which I think if I were to give a thumbs up or thumbs down or otherwise grade the papers, the United States Supreme Court.
Well, I'm not going to argue with any of the nominees, but there's nothing pending right now that would involve your, in effect, commenting on something that is potentially before a court where you would serve. Let me go on to the rest of you and just give you an opportunity to respond.
Just as I'm a senator, my response will echo the other two colleagues, but I will say, as a district court, what does matter is binding Supreme Court precedent. And as long as the Supreme Court precedent, looking at it analytically from a legal perspective, it is right. And so as long as that's the precedent, then yes, we will follow it.
Thank you.
Senator, it's binding precedent, and I would follow it if confirmed to the district court.
Senator, I agree with my colleagues. I will follow all binding Supreme Court precedent, including Obergefell, if I'm fortunate enough to be confirmed to this position.
Thank you all for your responses to my questions, and thank you, Madam Chair.
Senator Moody.
Thank you, Madam Chair. That's fun to say. And I apologize for my colleague, Senator Kennedy, who thinks he's a law professor during these hearings and launches into the Socratic method. Probably gave you nightmares and harkened back to law school. He indeed takes very seriously this committee's role in making sure we have the highest caliber of those that are confirmed for these lifetime posts. So we certainly thank the President for nominating such well-qualified and hardworking individuals whose accomplishments are great, but from what I can tell, your commitment to the Constitution and the rule of law may be even greater. And so I am very proud to be here today and participate on this committee. I have actually, as you can see, I am the newest member of this committee, but yet I have served in the judiciary as a judge and in the other branches of government. I was a state attorney general and a federal prosecutor at one point. So appreciate the breadth of experience that this panel represents. Thank you very much. But I'm not letting you off the hook, Moody, and I think it's only right, since I am Senator Moody, to question Attorney Moody. One of the biggest threats, I think, right now to our republic is the delicate balance of power that we have in our three separate branches. And again, having served in every branch, I think for the continued strength and prosperity of this nation and the freedom of our people, we have to always go back to a very strict respect of the scope of power of each of the branches. And from Thomas Jefferson to Abraham Lincoln, there has always been a concern of judicial tyranny. And that if you have a judge or a body that is consistently given the task of checking the power of the legislative branch or checking the power of the executive branch, that in turn, that unchecked judicial power may evolve into a type of judicial tyranny or oligarchy. What concerns me is the increasing perception by the public of the judicial branch, because I believe the failure of many historical nation states started when people stopped trusting the judicial branch, started inferring that the judicial branch cared more about policy preferences or political influence than they did about reason and analysis. And so I think right now the biggest challenge we face as a nation is the public's perception of this third branch and the danger that that presents to what was envisioned for this country by our founders. And we celebrate 250 years next year, what our future looks like as a nation. And so you will be given a lifetime appointment. Many have gone on to experience that horrible sickness called robitis. I've seen it many times. But I think where the danger becomes is where that overtakes the commitment to go back to what your duty is, first and foremost, as a judge, an independent judge with the job of using the Constitution and the law that's given to you independently without any bias. And so I would like to hear, and we'll start with you, Mr. Moody, and as far as I can get down the line, how do you believe your judicial philosophy or your nomination and ultimate confirmation will allow us to restore and ensure public trust in the judiciary?
Thank you, Senator. I am fully committed to this body to faithfully apply the law of the land, the Constitution, and all federal law faithfully and impartially, and treat all persons who appear before me with dignity and respect, and to give each case and controversy, as Article 3 specifies, the attention that it is due. And I will add, this body conducted a hearing on the judicial branch being the least dangerous branch as specified by Alexander Hamilton in Federalist Paper 78. It's only the least dangerous branch, Senator, if the judges, if we're fortunate enough to be confirmed, remember our role, Senator, as one of 3 separate but equal branches of government and not attempting to legislate from the bench. And I'm committed not to do that if I'm fortunate enough to be confirmed.
And I see I'm out of time, but I thought it was only fitting I started there. Everybody else starts with you, you poor thing. Madam Chair?
Thank you so much, Senator Moody. And on that note, I'll go ahead and start with him as well, so that way we can double up. Look, each of you have outstanding and unique qualifications to serve as federal judges, whether it be as judges or advocates. Each of you bring the necessary and important experience to the federal judiciary. Mr. Moody, we'll start with you. Can you speak to what experiences you've had over the course of your career that make you feel most qualified to serve in the position in which you've been nominated? And then we'll go all the way down to Justice Chamberlain.
Thank you, Senator. I grew up in the courtroom. I was born on my dad's first day of his last semester in law school. I remember watching him try cases at a very young age. I remember working as a runner in his law firm and deciding I wanted to be not just a lawyer, but a litigator in the courtroom at a very young age. And after 17 years in private practice and trying cases in federal and state courts, appearing in federal and state courts across the country, I feel like I was born to do this, Senator, and serve the public and my country in a manner that I feel like God has set me on a path to be back in the courtroom, but for a lifetime appointment serving the public and a country that's given me so much, Senator. Thank you.
Thank you.
Senator, to echo Mr. Moody's comments, I was also raised by a lawyer, and he taught me at an early age the important aspects of justice. As I said, riding to schools those mornings, we were listening to trial lawyers lecture, and I've taken that with me. I've been very blessed to have my own legal career kind of based on his shoulders. For the past 16 years, I've served as a judge on our state's highest courts, and I've had the ability to decide basically every aspect of criminal and civil case. I've been around some excellent mentors on both the state Supreme Court and the Court of Appeals. But to truly get down to answer your question, what kind of separates me and uniquely qualifies me to serve in this role is the fact that I've been a federal prosecutor in the Northern District of Mississippi. And it's where I cut my teeth as a lawyer. I learned a lot of lessons from the judges there, some tremendous judges. Neil Biggers, Alan Pepper, Glenn Davidson, Mike Mills. I learned lessons and also took a lot of lumps. And that is a part of the experience. We've heard a lot of questions about policy, about the Constitution, but what it gets down to as a judge is when you walk in that courtroom, can you not only call balls and strikes, like we have always heard the analogy from Chief Justice Roberts, but can you have a consistent strike zone for all the parties? What's a strike for one lawyer or one party can't be a ball for another. And I can submit to this committee that if I'm confirmed to this position, it would be like coming home to that federal family in the Northern District of Mississippi. Thank you.
Justice Lewis.
Senator, I come from a background where I was the first person in my family to graduate from college. We came from a meager background. And when I go to court, especially in the early years of my legal profession. I saw myself in a lot of clients that came through there. Not necessarily the criminal ones, but just in general. And that's one of the things that really has shaped my legal career. I believe that, and my judicial philosophy, I believe that everybody that comes into that court deserves to have their voice heard, regardless of where they are on the issues, regardless of where they come from, regardless of what they look like, regardless of who they are. I pretty much spent just about every minute of my legal career as an attorney in the courtroom. I practiced in civil litigation, I practiced in criminal litigation, I practiced as a prosecutor, defense attorney, I handled civil rights cases, I handled civil cases. I've practiced in 3 states, and so I've got a broad background that I bring with me to this potential judgeship. But then also those experiences as a lawyer factored into the way I handled myself and carried myself as a judge. As a circuit judge, my circuit was one of the busiest circuits in the state of Alabama. I handled pretty much more cases in my circuit as any circuit judge in the state based on our caseload. And what that taught me was to manage dockets efficiently, but also to make sure that everybody did have their voice heard. When I went to the appellate level, it was much different because then I was in a position where I was able to be analytical. I was able to research cases. It also gave me the opportunity to see how other judges in the state did things, what worked, what didn't, and how they treated people as well. And then when I became a Supreme Court justice, the focus shift. Of course, I was still working on trying to get a consensus. As a trial court judge, what I say goes, and if you don't like it, appeal, right? But then as an appellate judge, you've got to get a consensus. You've got to get other folks to gravitate to your issues. At least you have to try to. And that helped hone my skills in being analytical with legal arguments and things of that nature. And also, as a Supreme Court justice, we're dealing more with state and even, to an extent, federal policy. And so I have a broad background on every level of the legal profession, and I believe that will be very beneficial if I am to be confirmed as a judicial nominee.
Thank you. Mr. LaCour.
Thank you, Senator Britt. I've been fortunate in my career to get to cover a broad array of legal issues in a broad array of venues, from the Northern District of California to the Southern District of New York, from the Middle and Northern Districts of Alabama all the way up to the United States Supreme Court, litigating nearly every one of the Bill of Rights and many other issues as well. And I think that's given me a good experience in terms of being able to get a new issue, get up to speed quickly, try to get the right answer, and then move on. And I think that's a really important skill for a judge to have, to be able to master an area of the law quickly so they can provide justice both by getting to the answer that the law demands, but also getting an answer to the parties before you quickly so they can either appeal or move on with their lives. And so that's something that I hope to be able to bring, is a degree of skill and a lot of hard work to the bench if I'm fortunate enough to be confirmed.
Thank you. Justice Chamberlain.
Senator, first, I hope I'm not out of line if I correct a terrible omission from earlier today. I did not mention my father, who passed away in December, and his 91st birthday would have been on Labor Day. He would have been so proud today. To answer your question, I did not grow up the child of a lawyer. My father was a truck driver. My mother worked an assembly line. My earliest legal influences were Perry Mason and Ben Matlock.
I like it.
But my father and mother instilled a sense of the necessity of education in us, and I'm happy to have obviously obtained a law degree. My experience that most prepares me for this job is that I served 12 years as a circuit court judge. That's the trial judge level for the state courts in the state of Mississippi. I've run a courtroom. I've run a docket. I know the appropriate judicial temperament. I know the appropriate judicial demeanor. And I would hope to be able to bring those to the job if I'm fortunate enough to be confirmed.
Thank you very much. I am out of time, but the beauty of being the chair is you get to take more time. So I'm going to come right back across just very quickly, if you don't mind answering. What qualities do you have that you find important for a federal judge to aspire to and that you hope to emulate on the federal bench? And many of you may have referenced this in your previous answer, which is fine for you to reference back to that. But we'll start with you, Justice Chamberlain.
As a U.S. District Court judge nominee and for a U.S. District Court position, first would be with any judicial position, integrity. I think integrity is about as important as it gets. Of course, a dedication to the law and an appropriate, for reasons I did just mention, appropriate judicial demeanor and appropriate judicial temperament.
Excellent. Mr. LaCour.
So I'd like to think that I've learned from my former boss, Chief Judge Pryor, the value of, as I mentioned before, hard work. He recently served, or was commemorated for serving 20 years on the 11th Circuit, and several of his colleagues had commented in the Alabama Law Review that there are few judges as hardworking as him. Now, he's well known as a sharp legal analyst, and I hope I can be the same, but in terms of just getting opinions out the door, again, getting justice to the parties, something that I've admired and hope to emulate.
Thank you. Justice Lewis.
Yes, Senator. Work ethic and integrity is what I think is the primary characteristic of a judge. I believe that my long legal career has taught me that most people, regardless of where they are on the issue, when they leave a courtroom, it's my job as a judge to make sure that they know that the system has worked, maybe not in their favor, but in the fact that they have had their day in court, have had their say, and feel like the system is working for them. And I think Senator Moody touched on it a little bit. The perception of the judiciary is in a state that concerns me. And I believe that as a district judge, it's our role as being on the federal level that has the most access to the public to instill that confidence in everyone that this system works for everyone. Whether it be a traffic ticket or capital murder litigation, which I've been involved in on numerous occasions as well, at the end of the day, that person needs to feel like the system is there to hear them and make them feel like they are a part of this country.
Justice Maxwell.
Senator, I believe that integrity is paramount. Respect for the litigants before you is extremely important, and another quality that hasn't been mentioned yet is courage. Judges have to have the courage to make difficult decisions. You can't just put your finger in the air and check the pulse of what's going out there with your constituents, because we only really have one constituent, and that's to the law, maybe two, to the Constitution of the United States. And judges cannot push the law where they want it to go, or we all get to the wrong place. We have to follow the law. And if we do that, everyone in this room is going to end up in the right place.
Thank you. And the last word of the day to Mr. Moody.
Thank you, Senator. My colleagues have given excellent answers to this question, and I don't want to repeat any of their attributes. So to give a different one while adopting all of theirs, preparedness, Senator. I've practiced for long enough to know that a lawyer and their client can tell when a judge is not prepared for a hearing or for a trial or for an appearance. I've learned from a lot of great mentors, know what you can control, and I teach my young litigation associates that you can control your level of preparedness when you walk into a courtroom. And that's something that I tried to do every single time I set foot in the courtroom, is make sure I'm the most prepared. I would take that to the bench, Senator, and instill a level of confidence, not just with the lawyers, but with the parties themselves. This judge is prepared, and the preparedness shows respect, and the preparedness shows integrity, Senator.
Thank you so much, Mr. Moody. Well, thank you all for your time today. Congratulations on your nomination. Congratulations to your families. We are thrilled to have each and every one of you here with us. Thank you to the nominees, obviously, for your testimony today. Written questions for the record may be submitted up until September 10th at 5 p.m., of which the quicker you get back your answers, the faster we get to have an opportunity to put that before the full committee. And with that, thank you again, and this hearing is adjourned.